Good afternoon, everyone. We shall start with the 7th session of the 2-day orientation program on new criminal laws. The topic for the 7th session is digital evidence under Bharatiya Saksha Adhiniyam. The resource person for the 7th session is Shri Rajasekhara N, IPS, Director, CDTI, Hyderabad. I would like to request sir to please grace the dice. Yeah, please. No, this is. Sir is an IPS officer of the state of Nagaland State Cadre. So, sir is very familiar with this part of the country. And sir has also been to Manipur as a resource person for some other program. So, I'm sure many of the police officers and some other participants are familiar with sir. So we are privileged to have you as one of the resource persons for today's program. Now I would also like to request Shri C.H. Momont, Professor, LMS College and Panel Advocate, Manipur State Legal Services Authority. So to please grace the dice. Sir is also a regular faculty member of the State Academy training at Takil. So I'm sure many of the police officers and other participants are also familiar with sir. So we have two very dynamic and distinguished speakers amongst us today. Now the 7th session and the 8th session will be taken up together continuously without a break. I would like to request Shri Alek Muiva, Member Secretary, Manipur State Legal Services Authority, to please present a memento, Lengyant and a bouquet to sir. Thank you, sir, for the felicitation. Now, I would like to hand over the rest of the session to our moderator, sir.
Very good afternoon. So, without wasting any time, sir, it's better to start because you have to. So, session 7, that is digital evidence under BSA and review of BNSS addition, deletion and modification of session 8 will be held together. So, sir, please take your own time, and time is up to 4.
Good morning, good afternoon, everyone. So, few things, since there was we starting almost 20 minutes delay. We will combine both the sessions, and the reflective session we will after both the sessions. This is the number one. Number two, no tea break, I think. After 4 o'clock only. Okay. Then another thing, I will cut short my presentations because the presentations are huge, and I will concentrate only on the relevant facts, so that it will be, I can finish off this one. And the electronic evidence I am covering in the Bharatiya Sakshi Adhiniyam. So I will skipping many of the slides which are not relevant or which is of less relevant. So please be sure, and please note down your questions, and thereafter we can have a very, the questioning answer is the most important thing. See, out of the 3 laws, the least changed law is the Bharatiya Sakshi Adhiniyam. 170 sections, 170th section is the repeal and the savings, and the important things that has been changed, the addition of only 2 sections. One section is section 61, that is the electronic evidence, digital and electronic evidence, and another section is 170, that is the repeal and the savings. But lot of sections and the clauses have been deleted and added also, isn't it? And up to section 17, that is admission stage, the way to remember the old act to the new act is that there is a difference of 2. So whatever there is section 9, for example, the test identification period in section 9 of the Evidence Act now falls under section 7. Thereafter, we will have the multiple gap between these things. Because in admission stage, 5 sections have been, 6 sections, in fact, have subsumed in the 1 sections, within the sections. So there 6, and section 22A has been deleted. This is the one thing. That's why section 25, 26, 27 now appears unitedly under section 23. This is the number one thing. Section 25, 26, 27. 25 is that the confession made to the police officer. 27 is the recovery leading to the material evidence that is admissible before the police officer. And thereafter, section 32. What is section 32? Dying declaration. Now appears under section 26. Next, section 45. That is the expert opinion. Now comes under section 39. Now what is the difference? In section 39 and section 45, a new word called experts in any other field is also added. Because earlier, art, science, foreign law, JQD and all were there, but now experts in any other field is also added under section 39. So these are the important changes that has been there. And section 57, earlier section 51, 9 to 61, that is the primary evidence. Now under section 57, 4 new definitions have been added. 4 new definitions under the primary evidence have been added in section 57. So that is another thing. And secondary evidence also, some minute changes have been made. And shall presume, may presume, earlier in the form of definitions have come under section, here in section 2 only. So no separate definitions have been there in this one. So we will see to that one, and we will concentrate on the section 61, section 63(4). Earlier section 65B, that is the certificate that has to be issued for the electronic and digital evidence under section 65B, now comes under section 63(4). That means what makes the difference is that earlier section 65B, we have only one, that means a certificate has to be given. Now under section 63(4), we have to give 2 certificates. One by the controller or the owner of the data of the electronic evidence, and second certificate, that is form 2, has to be given by the expert. And one of the madam has covered who is an expert, but again add to that one, expert is the one who is as stated under 79A of the Information Technology Act. For that, the state government has to bring a notification who actually is an expert as far as the section 63(4) is concerned. So these are the overall views. We will go into detail a little bit later. Okay. So another thing, only important thing, definition of India has been taken off. See, if you see cyber crimes, virtual private network, Chinese app loans, Tor browser, Onion browser, deepfake, deep web, dark web. And why it is called Onion browser? Because when I am searching any internet, you can trace where the server is there. If you go to the keylog and see what are the hops, isn't it? But what happens in the Onion browser means you cannot trace where the server is called. That means there are multiple servers. That means to say that any offense that has been committed outside India, now it is difficult to trace where exactly the email come from and all those things. In the Onion browser, also called as the Tor browser. Why it is called as Onion browser? Because like Onion has different layers, like server has many layers, so that I cannot trace back the original server. So these are the things that has been there, especially using the cryptocurrency, using frauds online. Now what happened, the word India has been taken because to give a territorial jurisdiction beyond India. You might have seen the Chinese app loans. App loans were made in China. They hired up people there, or they have some accomplices in India and commit the fraud in India. Earlier, even within India, jurisdiction was a major fact, major hurdle. For example, the Mewad region in central part of India, northern part. It touches with Haryana, Delhi, UP, Rajasthan. So what the crimesters, fraudsters used to do, they make a fraud here, just sneak into the other place, and the territorial jurisdiction issues were coming, even within India. And outside India also, our IT Act is not applicable, isn't it? That's why if you ask section 65B certificate earlier, now section 63(4) certificates to Google, Facebook, Twitter, Instagram, they give the information, they don't give the certificates. Ideally so, because they are not entitled to adhere to the Indian laws. That's why the word India has been taken off from the very definition of the Bharatiya Sakshi Adhiniyam. Okay? So presumption as to telegraph messages has been gone because obviously the telegraph is no longer used and all those things. This I will not go into the detail. Next parts. Section 26. Explanation deleted under Indian Evidence Act. Confession by accused while in custody of police not to be proved against B. Section 65B, fifth explanation. Verification of digital signature. Presumption as to electronic messages. See, look at the 73A. Digital signature and electronic signature. You find the definition in the under the Information Technology Act. What is a digital signature and what is the electronic signature? In layman point of view, I will explain you digital signature certificate. What does it mean? It means that, for example, what you do, you go to income tax, you file your income tax and give the Aadhaar authentication. It will send a OTP and file your income tax. That is called as a digital signature or the electronic signature. In other times, what you do, you make your signature, take a photograph and affix wherever it is. There another one called digital signature certificate. You might have seen the dongle type of a thing. That is the pink colored one, which is given by the ESL, Mudra services and all those things, where you can file the income tax or anything via either digital certificate, that is the putting the dongle, or through Aadhaar notification. Isn't it? Electronic signature is that you sign it and paste it there. Now, digital proof as to verification of digital signature has been taken off. Next, this I will skip it. Modification. Definition document includes electronic and digital records. Isn't it? That is very important to undo. Documents means what are the things? Letters, figures, marks, means intent to be used, including electronic and digital records. So section 21D is a basic thing for the electronic and digital records. This is the thing. Next, these are some of the things as document is stolen and produced to the court, whether relevant. Now, how many of you say with whether it is relevant or irrelevant? Whether relevant or irrelevant? It is relevant. In other ways, in matrimonial cases, what happens? Wife steals the husband's mobile and she produces into the court. Whether it is admissible? Whether it is admissible? It is admissible. Now, Can she be charged for stealing of theft one? Yes, that is a separate thing. Or wife or somebody hack into my mobile phone, which is admissible in the record court, take that one and produce in the court. If it is genuine, it is admissible. But what is he charged? He is charged under section 43 of the ITA Act. That is unauthorized access of an electronic this one. So these are the things. Because this has a root in America. There is a rule called roots of the poisonous tree. There this principle comes there. That means stolen and produced also. Emails, server logs, documents, laptop, smartphone, messages, websites, locational evidence, voicemail messages, digital evidences or documents. Now if you see locational evidence, what does it mean? LBS, location based services, IPDR, CDR, they are all comes under the definition of documents now. Okay. Now evidence electronically, oral, I will not go into this one. Under statements including evidence, electronically, logical currently 530. So 530 is the last but one section in BNSS. Section 530 of the BNSS says all searches, warrants, everything can be issued electronically. We will come to more detail when we deal with the BNSS. Okay. Electronic records were treated as documentary evidence. No express mention digital records. But now it has an express mention. Okay. Now if nothing has been proved or defined, then you have to go to this other laws for a particular definition. Okay. Another word, barrister, pleader, vakil. Now only word called advocate. For just a simplification, lawyer who passed the law degree, barrister passed the law degree in London, pleader, one who takes the cases on behalf of the government from a particular department, advocate, lawyer plus who written the bar council examination and has the license to practice. Now all these words are there. Now only one word called advocate in the entire law. Now all these words are replaced by advocate. Next, whether it is relieved, does not go into section 22. What is the first change? Coercion. Confession caused by inducement, threat, coercion or promise. Remember Indian Contract Act. When the contract is not correct or void in ab initio or void, there you find if it is of distress, duress, misrepresentation, coercion. On the same lines, now coercion has been added. But the thing is that there is a coercion in threat and there is a threat in coercion. If you speak legally into the legal terms. Then 22(1), 24, 22, this one and all those things. Coercion has been inserted in section 22. Next, confession by the co-accused is irrelevant. Now what happened? Joint trial. Confession of a person against a person who is absconding, that is also relevant now. That is especially we will deal with the proclaimed offender under section 84(4) or under joint trial. Okay. Now promise of secrecy, deception practice, drunk answer to the questions not warranted. Look at them. In the morning one of the honorable member was asking a question. For example, during the practice of law, the person came to me and said that I committed a murder. I made a terrorist act. Under professional secrecy, I am not there to declare it open. But somehow the court came to know that, yes, he has made to that lawyer that this one. As I told, somebody has put a CCTV against me and it has appeared in the court. Now that is admissible. Isn't it? Of course, the next question is what is the security breach and all those things. That is there. Next, whether relevant may know. Again, I will skip this one. Accused, co-accused in this one. When more persons than one are being tried jointly for the same offense, confession made by one such person affecting himself and some other such persons is proved, may take into consideration. That's what the proclaimed offender or the absconder also included. More than one held under, that's what I was explaining. 84(4) of the, you can add 4 also. Who is absconded or who fails to comply with the proclamation notice. 84.4 is the proclamation of offender under the Bharatiya Nagarik Suraksha Sanhita. Now it says that any offense punishable more than 10 years punishment. Now in those cases, a proclaimed offender can be illustrated, can be declared. Earlier it was not clear, but now it is clear. Next, expert obedience. This one. Any other field after foreign law, science, art, handwriting or finger impression. Now expert opinion also includes any other field. Now what does it mean? By the course of practicing this one, by having enough qualification, a person can be added as any other field, because in certain cases what happened in one of our CBI case, what happened, there was some Arabic documents has to be translated to the Hindi. Now we get it translated by a professor in some of the college, isn't it? Like those kind of situations arise. Very, very important thing is section 57. Earlier section 262 of the Indian Evidence Act. Now primary evidence. There are 4 new definitions that have been added in the section 57 of the primary evidence. Very, very important for the prosecutors, for the judges, as well as our police officers. What is the first one? Electronic digital record created or stored simultaneously or sequentially. What does it mean? For example, I took a photograph. I took a photograph means it will be stored in my mobile in multiple spaces. Not only in gallery, not only in internal storage or in this one, correspondingly or simultaneously. Then all those copies are considered as primary evidence. We cannot say whatever there in the camera, that is the primary evidence. If it has gone to the internal memory, it is the second evidence. No, it is the primary evidence. Here question comes section 105 of the BNSS. Yesterday we were discussing. Lot of questions were asking, sir, what happened to the video that has been taken during the search and seizure? Somebody also pointed out e-Saksha app. For example, I gone to the scene of crime, or I gone to the or wherever the search and seizure happened, I took a videography of the search and seizure. Now what I do, I do not download it. I will not download it to a pen drive. I use the e-Saksha app. I will send it to the court through that app. The beauty is that it cannot be downloadable. Only the link is shared to the court and link is shared to the accused person or whoever be there. Now there it comes. Recorded, created or stored simultaneously and sequentially. Whether I need to take the 63(4) certificates? No. I took a videography of the scene of crime or the search and seizure. I upload it in the e-Saksha app and send it to the court, the link. I need not to give the section 63(4) certificate or the earlier section 65B certificate, because it comes under section 5, 57(5) of the new law. Then electronic digital record produced from proper custody. Now what happened? Proper custody means that is the same thing. For example, mobile belongs to me and somebody has stolen it and gain it, but it is admissible, isn't it? Proper custody. It may be proper custody in another things that I will give an example. There is a DC office, there is a data operator is there, who gives the caste certificate or the tribal certificate, isn't it? Then who is the proper custody person to give the 63(4) certificate, whether the DC or the person who is controlling the computer? What is the answer? The operator. Although DC is the head of the institution, although DC has approved the issue of certificate on the file, yes, so and so person can be give the caste certificate. Now who is the proper custody to give that certificate 63(4)? It is the computer data operator. Why? He is in the proper control and the day-to-day functioning of that computer. Got it? So that's why electronic digital record produced from the proper custody. Video recording that is simultaneously stored in electronic form and transmitted to or broadcasted or transferred. It is almost the corollary of electronic, that first one. There it is the electronic digital record. Now it is this one. For example, you take a videograph and you uploaded it like e-Saksha Adhiniyam, e-Saksha. Take the videograph of the scene of crime or search and seizure, send it to the e-Saksha app to the court. Next, electronic digital record stored in multiple storage spaces in a computer resource. Very, very important. Now what happens? I will give an example. You might have heard of a file system called File Allocation Table, FAT. You also heard of a file system called NTFS, New Technology File Transfer. If you put some of the pen drives, immediately a pop-up comes. This is not supported by FAT or NTFS. Have you seen this pop-up? Many of the cases, because each of the storage capacity or each of the system, how it stores, it depends upon the operating system. Now to elaborate this one. There is a document of 7 MB. There is a document of 7 MB. What I will do, I will store in the computer. When it store in the computer, it will allocate 2 MB, 2 MB, 2 MB, 2 MB sectors. So 7 MB means how many sectors it occupy? 4 MB. 2 MB first sector, 2 MB, third MB, 2 MB, so 6 MB. 1 MB will be occupied by the fourth sector. Okay, tomorrow I add another 3 MB, another document. Now, whether 1 MB will be stored in the fourth sector or it will occupy the new sectors. What is the answer? It occupies the new sectors. It will not go and occupy the fourth sector where there is 1 MB vacant. Isn't it? So it will. So if you go to the computer in a technical manner, how the files are being stored, you can see the dots of yellow, green, red. Have you seen anybody? There you can see some of the files have been stored here. The same part is stored here, same part is stored here. Here there is another question. I have a 100 GB hard disk. Please pay attention. 100 GB hard disk. August 1, I put 10 GB. August 2, I put 10 GB. Like that, August 1 to 10, I put 10 GB, 10 GB, 10 GB, 10 GB. August 10th, my hard disk is completed. Okay? August 11th, I deleted 50 GB. Shift deleted. Shift deleted. Now, whether shift deleted means it entirely wipe out the memory? No. Can I recover 50 GB back? How many will say, yes, I can recover 50 GB back? Please answer. Let us be interactive. Yes. Although you made a shift delete, you can recover the 50 GB back. As long as it is overwritten. As long as you put another 50 GB on top of that one, still you can recover the shift deleted files. That is how police officers do the investigation. When you take a mobile, using the oxygen, X-ray and all those things, shift delete does not mean that it will go out of your memory. Make sure. So what to do? You have to overwrite. Then only you can get rid of the earlier memory. Okay. August 11th, I deleted 50 GB, shift deleted. Actually, visibly, I can only 50 GB. 50 GB has been shift deleted. I cannot get it. I cannot see it. But what happened? Now 50 GB is available. 50 GB as of now available. 50 GB you can recover using forensic tool. August 12th, I add another 30 GB. Another 30 GB. Then how many GB which has shift delete I can recover back? 20 GB. Now the question is which 20 GB? Whether August 1st and 2nd or 9th and 10th, 3 or 4th, which 20 GB I can shift delete? Any answer? Huh? Random. So we cannot say which GB I can recover, because again it depends upon the multiple storage spaces in a computer resources, where the spaces it occupy we never know. Okay, that's why I have given the full illustration of the 4 examples, especially for the primary evidence. Next, 61. This is the brand new section that has been added. You know there are 4 case laws in the electronic evidence. Navjot Sandhu case, way back in 2005, Madam was also telling in the morning, isn't it? Where they said, yes, secondary evidence, for primary evidence, no need of certificate and all those things. It was overturned in 2013, PK Anwar versus PV Anwar versus PK Bashir case, a Kerala case, a election related mobile case, where it said that section 65B certificate is necessary for the secondary evidence. Then came the Shafi Ahmad case, Shafi Ahmad versus the state of Himachal Pradesh, where it said that in all cases, even for the secondary evidence, 65B certificate is not required. When I say 65B, it is the old law. New law is 63(4) certificate. Then everything was cleared, and the Supreme Court held up the PK Anwar versus PV Anwar case and set aside the Shafi Ahmad case in Arjun Pandit versus Kailash Rao case, Maharashtra Jalna district case, where it says that 65B certificate is compulsory, number 1, and you have to produce at the stage of evidence. At the stage of evidence, that certificate is to be produced. That means to say that at the time of charge sheet, you may not be having 65B certificate, but the stage of evidence, admission, your 65B certificate is required. And the same thing has been retained under section 63(4). Now, as per as 61, take the certificates, 2 certificates, and produce the IO. Even though he is not able to get at the stage of charge sheet, but he has to be equipped with these 2 certificates at the stage of admission, when it comes to the admission of the electronic evidence. Now look at this sentence. The definition starts from a negative connotation. Nothing in this adhinayam shall apply. What does it mean? It means 2 things. It supersedes the earlier thing. It is the superseding section, isn't it? Nothing. Second thing, why nothing has been added? Can anyone else tell me? This one? Because why nothing has been added means, what is the definition of electronic evidence? We saw that one. Logs, call records, location based evidence, websites, and all those things we saw. That is the electronic evidence, but that is not exhaustive. Today, I have many electronic evidence. Even this is an electronic evidence. My button may be an electronic evidence if it is a spy camera. My watch, smartwatch may be an electronic evidence because it is a smartwatch. The TV I am using is a electronic evidence. The tie I am wearing is a electronic evidence if it has a spy camera. You know, Internet of Things. So now deep fake is there. Everything. So many electronic evidence are there. Now what happens, a new type of electronic evidence comes tomorrow. Now can you tell that no, the new type of electronic evidence is not included in the Bharatiya Sakshya Adhinayam, hence it is not admissible. Can I tell that one? No. That's why they added the word nothing. That means to say that even a new type of electronic or digital or electronic gadget comes into the market tomorrow, then it is admissible. Way back 15, 20 years back, we were using floppy disks. Are we using it now? No. Floppy disk gone. Even the FSLs does not have the facility to test that one. Maybe outdated, our pen drives may be outdated. FAT system has been outdated. New came, deep fake came, deep fake video came, new software came. Now they are all admissible because of the section 61. Please make note of the section 61. That is the admissible electronic or the digital record under the section 61A, that is the newly added. Now there is no confusion, there is no court case, electronic and digital records are the definition under the document. Okay. Next, landmark case on the electronic evidence. I will not go into this is Thomas Bruno versus State of UP. This is relating to CCTV camera. I think in the terrorist case it has been added by morning or yesterday. One of the other faculty. It is relating to CCTV footage. I will tell you in a short while. 3 Italians came to Varanasi, Uttar Pradesh, checked into the hotel, Out of the 3, 1 was killed in the hotel. Now, based on the circumstantial evidence, the Sessions Court took up the view that these 2 Italians killed the 3rd one. Okay? High Court, yes, confirmed it, because you know, Sessions Judge can give a death sentence on the conformity by the division bench of the High Court. Matter went up to the Supreme Court. Supreme Court set aside the lower court order. It says that the important piece of evidence in this murder case is one of the electronic evidence, that is the CCTV footage that was put in the hotel. Now, what are the reasons that the police did not collect that CCTV footage? No CCTV footage collected. That is the important piece of electronic evidence. Hence, the death penalty was set aside. A landmark case in Thomas Bruno case. Okay? I will not go into the facts. Again, I told everything. Decision, reasoning, and all those things. This anyway, the PPT will be available for you all people. You can later look at this one. Footage, Honorable Supreme Court. And the court observed the CCTV footage was not collected due to the fault of the investigating agency. Isn't it? Okay, court, same was not produced. Their conviction order was set aside. Okay, next. Next, electronic evidence, earlier section 65B, 60, now it is under section 62, 63. Now, Information Technology Act, documentary evidence, contents of electronic evidence, okay, primary and secondary evidence, again, basic things. Contents of electronic records may be proved, admissibility of electronic records earlier, now another thing. That was there in the section 65. Now, what are the conditions for a computer to get an electronic evidence? First says, used regularly. What does it mean? Mobile is there. I used it for 2 years. Then discontinued, it was battery down, everything down for 4 years. Later on, I used it for the 5th year. Now, whether was it used regularly? No. That means to say that any electronic, this one gadget should have been used regularly unless and until some brokerage happened in the between and it was legally found out. Then information regularly fed. Again the same thing. Anybody? Okay. For example, the information regularly fed. You might have seen the companies. You might have seen the office. For example, if we go to the banking sector, I will produce the check. Isn't it? I will produce the check. What the first cashier will see? He will check whether my signature on the check tallies with the signature in the computer system. Because these days it is a truncated check. It will not go to the collection branch. Then it will go to the another cashier, another person. They will check whether amount is there. Then it will go to the another this one. They will check whether the check is already proper or not. Then it will go to the pass. Isn't it? So the information has been properly fed. Even if you go to the bank and open an account, you give the account this one, you will fill something, then it will go to another, then it will go to another. So it was regularly fed. Isn't it? Regularly fed. Computer was operating properly. As I told, computer was operating properly. Some virus attack was there. For example, sometimes in the laptops, you will get a very greenish kind of a thing when the computer is broken down. During that time, you collected evidence. Do you think that the computer was operated properly that time? No. Then information fed in ordinary course of activities. Very important. Now, I will give a very unique kind of a situation. A document as prepared by the judge office. Judge office. Now, with an intention mind, what I do, I broke into the judge's house or judge's office in the midnight and I put some of the information. I know that the morning the computer operator is coming to take out the printout. Okay? I put it something which I needed. Whatever it may be. Morning the computer operator came, he provided and he gave this one. Now, do you think that the ordinary course of action activity was there? No. It was not there. Isn't it? Next, functions performed by combination of computers. What does it mean? WAN, LAN, wide area network, local area network. There is a combination of computers. You might have seen computers based on bus, in a tree manner, parallel, series connection. Different computers. Now, different computers means what? For example, here only I can give the example.
Ma'am, announcement Hyundai Grand i10, dark grey color, MN01AG 1950. Yabirak yabra. Si gate ki wang mo kamamba. I guy number of the Hyderabad Grand i10 Hyundai gi MN01AG 1950. Gate ki opposite kamamba. Okay, thank you.
Okay. Now, combination of computers, different computers. Now tell me, this PPT, I made it in my laptop. Then I transferred via Bluetooth to my mobile. Mobile is also a computer system. Then from mobile system, I transferred it via WhatsApp to one of the assistants here, one of the officer here. From WhatsApp, it has come to this computer. That is whatever the laptops are there. Now see, that has been series of computers used. Different combination in succession. Different tree, bus, area, what all the combinations. Then in any other manner. Okay. These are the things. Cases, Anwar versus PK Bashir, Arjun Pandit Rao Kotkar case. I already explained these case laws. Later, please go through with these case laws, especially on the electronic and the digital, this one. Just you can mention the name of the case laws, Anwar PK, PV versus PK Bashir, and Arjun Pandit versus Arjun Pandit and Kailash case. Okay. Next, 62, contents remain same. 63, yeah, 63, electronic record, computer or any communication device. See, everything remain the same. Communication device has been added. Like that, the phone, smartphone, everything. The communication device has been added in section 63. Deem it to be also a document. Electronic record, printed on paper, stored, recorded or copied, optical, magnetic, semiconductor memory. Obviously, this semiconductor memory is also a new word added. So section 63, two things have been added. One is the semiconductor memory and another one is the communication device. Along with the computer, they are added. Okay, for the sake of electronic device. Otherwise, stored, record, copied in any electronic form shall deem it to be a document. Apart from that one, section 61 also says that paper record, which was not found in the earlier. What does it mean? It means, for example, I found a mobile. There the boy and girl have chatted in the WhatsApp, whatever it may be. Or a photograph. I took a photograph or chat in my paper, xeroxed or photocopy. Now that is called as a paper record. Isn't it? Paper record. Now that acquires the concept of primary evidence. That is equal to a electronic or the digital evidence, and it is a primary evidence. Please make sure, because our officers, police officers, they cannot produce the mobile to the court. What they do? Sir, these are the conversation between the accused and the victim. What I do? Whole WhatsApp messages, I will just put it in the paper and produce to the court. Whether it is admissible? Correct. It is admissible. Okay. It is not downloaded or anything as such. Drone as a communication device. So I will not go into the details. I have list out what all the electronic digital gadgets and where this one is there. So this is the one thing. Conditions of computer output, computer resource, communication devices, email, phone, etc. in standalone mode. Standalone mode means what? This computer is standalone, which is not attached to anywhere or only one device. Computer system, computer network. Now, what is a computer system? What is a computer network? The definition is there in the Information Technology Act. Please go through the Information Technology Act. You will find proper definition for all these things. computer resource enabling information creation or providing information processing or storage. Now, last one is through an intermediary. What is an intermediary? ISP, TSP, Internet Service Provider, Telephonic Services Provider or intermediaries. That's why please go through the intermediaries guidelines of 2021 by the MATI, Ministry of Electronics and Information Technology, which says that all the telephone companies has to preserve the call data record for how many days? 180 days. Now it is 180 days. Up to 180 days they have to keep the record of all the things, even the CCTV footage also. All the things in the companies had to keep the record for 180 days. Okay. 63.4, certificate along with electronic record. 63.4 is earlier section 65. Now what are the differences? 65B, 1 certificate. 63.4, 2 certificates. 65B, certificate to be given by the owner or the controller of the data. I give the example of DC office. She is not the owner of that computer. No. Owner still who lies with the Deputy Commissioner's office. But she is the controller of the data. Got my point? Okay. Now, whereas in 63.4, 2 certificates. Owner or the controller of the data along with the expert, this one. Expert as said by in the earlier session also, SHO or a senior officer or a forensic expert. Or as stated in 79A, expert that has to be notified by the state government. Then if a person in charge of the computer or communication and an expert that retrieves the electronic record. So there are 2-part certificates now. Another difference is that earlier in section 65B, there was no clear-cut format. Only you have to mention that, yes, the computer was performed regularly, fed in the ordinary course of activities, it was not broken in the middle. All these undertakings used to be given in the 65B certificate. But now, there is a fixed format for given for these 2 certificates. I will show you the certificates, 63.4, 2 certificates. That is called Form 1 and Form 2. Okay. So, Part A certificate I already filled by the party who owns, manages or maintains the computer device from which electronic record is retrieved. Part B of the certificate should be filled by an expert who retrieves the electronic record from the device. Okay. Sometimes it so happen that, for example, a CCTV footage is there in the traffic light. I will give one example. There is a traffic constable who is manning that there. The CCTV captures one through ANPR, automated number plate recognition of an accused vehicle. Now CCTV footage. Can you take the whole CCTV footage to the court? No. Although section 57 primary evidence says that as far as possible take the primary evidence to the court. But in more situations the primary evidence cannot be taken. For example, CCTV that has been put to the whole campus, can I take to the court? No. For example, a crime happened means for 5 minutes means on this day means I will take out that one, download it and produce to the court. IRCTC or SBI bank hacked. Can I take the whole this one? No. So that's why in the traffic junction, in the case of junction, whether the constable is entitled to give the CCTV footage certificate? No. Then who has to give the CCTV footage section 63 certificate for the crime happened near the traffic junction? The command and the control center. Please make sure, that's why I am telling proper custody. Although the traffic person was placed in the traffic junction, it is his duty. Some crime happened. No. It is the command and the control center who controls the data. Okay? Now, currently due to lack of format, but now there is a particular format. Okay? Entire computer never work on original, hash value, hack into IRCTC. So I will just dealt with hash value. Hash value is the digital footprint of any file or folder. Simple. Digital. Like I walk, I put a footprint. Like whenever I create a document or a folder in a computer, it creates a hash value. Now two questions. I typed a document called Manipur Legal and put it in F drive of my computer. Got it? And I copy it and paste it to my desktop. Now, whether the hash value changes. Whether the hash value changes? How many of you say the hash value changes? I take the file cut the file from F file or copy it and put it in my desktop. Whether the hash value changes? Hash value changes? No. Why no? Why yes? Why? First we shall go with why yes, hash value changes.
No, unless otherwise the file will be changed, then hash value will be changed.
Unless?
Otherwise, no change.
Can you repeat?
No, unless otherwise there is any correction or modification in the file, no hash value will be changed.
So your answer is that the hash value doesn't change in this case?
Yes.
From F drive to desktop?
Yes.
You have any other answer? Sir, you told that no hash value changes. Why?
Sir, we have changed the place now. So
The path changes. The path changes, the hash value doesn't change. Because hash value is related only with the content of the folder. Got my point? Okay. I will give another example. In the F drive, it is called as Manipur Legal. I copy it, put it in my desktop, and I gone and right click, rename it called Manipur Judicial. Now tell me whether the hash value changes. Yeah. So hash value doesn't change. What about you?
It will change
It will change. Why it changes?
because the file name has been changed.
Okay.
Modified.
What about you, sir? Now we are correct. That is the answer. Correction for you. The hash value doesn't change by renaming the file of the folder or the document. Please make sure. Hash value doesn't change by rename or this one. Isn't it? In this case also hash value doesn't change. Okay. Third. Manipur Legal, my folder is there in the F drive. Took it, copied it to the desktop, gone into the content, add letter A, then deleted A. Practically no change. Now whether the hash value changes. What is the answer? Why changes? Content on a whole it has been changed. On a whole it might not have been changed. Who says no, the hash value doesn't change? Anyone? The answer here is hash value changes. Because the moment you put a fresh hash value came. The moment you deleted the same a fresh hash value came. Because the hash value is not reversible. Got my point? That means based on the hash value, you cannot retrieve back the same file. There is no definite sequence in this one. Remember all these three situations, especially with the hash value, so that the judges and the prosecutors will not get this one. Okay? Now, another fourth situation. This was asked by one of the judges in Assam Judicial Academy. A bail petition has come and there was a question of one CCTV footage. Crime happened and CCTV footage came into the judge madam. Now judge madam want to see the contents of the data. Got my point? That was the original piece of evidence forwarded by the forensic through the police messenger, come to the court. The bail petition came. Madam want to see whether crime happened or not. She asked me, sir, can I see the file in my room, in my judge room, put it in my laptop and see the contents? Now, what is the correct thing? Whether she can, yes, she can see, as long as she does not change the file. No, she cannot see it unless and until it comes for the admission stage in the evidence, and when both the parties are this one. What is this one? She can see because she doesn't change anything. Huh? Yeah, that is another question, but it has been forwarded by the court. Okay, she doesn't change anything. She just want to see it. As already stated, just seeing the file, copying the file doesn't change the hash value. Now what is the problem? If the judge madam sees and sees the folder, hash value doesn't change, but what changes? The metadata, the properties of the file folder change. If you right click the file, if the madam see the CCTV footage, and later if you see the right click, it will say last access date will be shown the date when madam sees it on her computer, which the defense will certainly object. Ah, my lord, somebody in between have been interrupted. Although there is no change, isn't it? So what the best madam can see, madam can do? She can ask for another copy from the forensic, or there is a duplicate copy from the police. Now that's why there are two methods how to collect an electronic and digital evidence. Please bear in mind. This is followed in the entire country. Scene of crime, I found a laptop. What you will have to see, the police officers, when I see the scene of crime and the laptop is found, what I should have to see first? What are the procedure to collect the electronic and digital evidence? Videography, then before seizing, photography. Why photography is required? Because you need to mention the exact model, serial number, color of the laptop. There may be Dell laptops of same color like anything. Number one. Number two, photography, how it has to be taken. Police officers, please open your thinking this one.
With the scale measures.
Huh?
With the scale. Scale.
Scan.
No, measurement with the scale.
With a scale, okay, that is there. But what is the correct ideal to take the photograph of that, this one?
3 ways, sir, 3 ways.
Take the laptop photography with a reference picture. The same thing followed in collection of the evidence. For example, a blood has been there in the road. You take the close picture, but at the same time, you take the blood pattern with a reference point, proving that the blood sample was found there only. Like that, you have to prove that the Dell laptop or whatever laptop has been found in the same place with a permanent object. That is, oh, you take the photograph, serial number, mention everything. Now, the laptop is on. Now, what to do? What is the sequence you collect the electronic digital evidence? Police officers, please. How you will collect? Live? If it is on, you pull the cord. You will not shut down. I will come to that one. Before that, what you do? What are the two types of memories found in laptop? Volatile, hard disk. First, you have to see what are the temporary files running. That is found on the toolbar. So that is also called as RAM, Random Access Memory. So using a kit called Forensic Toolkit, FTK, what you do, you collect the RAM first. Why we collect the RAM first? Anybody? Correct. RAM is called as temporary memory. The moment you close the laptop or shut down the laptop, the RAM memory is gone. That's why stored in multiple storages. That's why you might have seen, you are working on a computer, there is a document, light gone. But resurfaces and asks whether you want to save it. Whether the file has been earlier saved it in the hard disk? No. It was saved in the RAM. Isn't it? That's why always collect the RAM data first. RAM data means temporary data. See what are the website he has open, what are the files he has open, what is the RAM that is open, what is the cookies there. You collect that one. RAM. So before collecting to the computer, to the hard disk, which one you use, police officers? What measure, one equipment you use in the between? Right blocker. Or you can use FTK. FTK, forensic toolkit, is itself this one. FTK is not a hardware. It is a software. It is an open source intelligence. You can download it for free. Please note down, forensic toolkit, FTK. It is useful to collect the electronic and the digital data. Okay. You collected the RAM data first. Then what to collect next? After RAM? Hard disk. So collect the hard disk with the right blocker, then download everything. Now there are two options to collect this hard disk. What are the two ways of making the collecting the data? What are the two ways? Both the ways you are using the right blocker. Imaging. Another one? Cloning. Have you heard this one? Police officers. So silent, why? Imaging and cloning. There are two methods of getting the exact data of the original hard disk. Now what is the difference? Tell me what is the difference between imaging and cloning, and what method the police officers has to use? Okay, imaging. Why imaging? First, what is the difference between imaging and cloning? While collecting the electronic and the digital records, digital evidence. Both are the same copies, but imaging means it will give the data as it is. It will not give the deleted data. Sorry, it will give the deleted data. Whereas the cloned image means exactly what it is as of now, it will give. That is called as clone. Exact identical bit by bit copy is called as cloned image, where the deleted files cannot be found. That is called as a cloned image. Whereas imaged copy means you still get the deleted files. So whatever the files that have been deleted, photos, videos that has been deleted from this computer, I can get while using the imaged copy. Number one difference. Now, as a police officer, which one I will prefer, whether image or cloned? Imaging. Because I get the deleted. Who knows? Accused has used many things, he has seen videos, everything, and he might have deleted it. But I want to recover it. Second, but which is easier to use? Which is easier to analyze the data? Whether cloned copy or a imaged copy. But easier to analyze is the cloned copy. Because to analyze the data in the imaged copy, you need extra software. Isn't it? You need an extra software to read the data that has been collected under imaged copy. Whereas in cloned copy, you need not need. You can directly access this one. So this is the difference between image and clone. Okay, now I am collecting the hard disk drive. I am using the right blocker. As you know, I prefer to use which method? Image method or clone method? Image method. Image, this one. That means to say that I had to use a original hard disk. If it is of 900 TB, I use the 1 TB. 900 GB means 1 big GB. Again, police officers ka galti hai. I have seen many of this one. What they do? Police officers, Mahan Bhav, they took the accused mobile, they see that there is still some talk time. They just use the talk time. Isn't it? They use it to take their own photographs. Pen drive has been seized in the case. What they do? They put their own videos and photos. This has been made by our police officers. So don't do all these things. So whenever you are getting the copy of the image copy of this one, use the fresh TB hard disk only. Or if the earlier hard disk if you want to use, make sure that not shift delete. It is called as wiping. Wiping the memory. For example, there is a hard disk, 500 GB. I want to entirely wipe it out, then only I can use it as a fresh one. Otherwise, don't use it. Okay? You copied image copy. Now, there are two methods to send it. In Kerala, Tamil Nadu, what they do, as soon as the original hard disk is taken, they send it to the court. Correct. Because after FIR, every property including the accused document belongs to whom? Court. So they send it to the court. The court will send it to the CDAC. From there, they will make 2 copies. One for the IO copy, one for the CDAC to analyze, and the original copy they send back to the court. This method is also correct. The problem is that from court to CDAC, CDAC to court, obviously the police officer has to go as a messenger and take it. And the problem of chain of custody. Yesterday, madam was telling chain of custody. Another way is that we were using most of the times is that scene of crime, right blocker, take all the contents into the empty hard disk. That empty hard disk where you collect the image copy, you keep it. That is used for investigation purpose. And the original hard disk, you send it to where? FSL. Straight away with 2 blank copies again. Why 2 blank copies again? Yeah, whatever you are copied from the scene of crime, that is only a copy for your investigation. That is not the copy given by FSL. So the official copy should be the one given by the FSL. That's why take 2 blank copies, blank hard disk, send the original along with the FSL. They make a imaging. They send the original one to the court through a police, and 1 copy they will give to the police, and 1 copy will be with the FSL for their report. Now the IO will have 2 copies. Why 2 copies? The first 1 copy is to be utilized till the FSL sends the formal copy. It takes time because imaging 500 GB hard disk means how many hours it will take? Any idea? No. It takes many days also. It depends upon this one. It takes many days also. That's why the IO first take a copy of himself using the right blocker. Then officially he gets a copy from the FSL. Both the methods are proper provided you maintained a proper chain of custody. There was one case that happened in front of our eyes. We sent electronic hard disk through packed to the FSL director, Meti in fact, Meti director. Our constable took the copy, he gone there, the gate man stopped him, he said, I want to deliver this to the director by name. Director has not yet come. What our constable did, he handed over to the gate man. When the director come, you handed over to the director. And he simply come. Now in the court, The defense asked the director, sir, whom has delivered you this electronic evidence? He told, my watchman XYZ has given this one. Whether the watchman name is there in the chain of custody? No. Case gone. Silly mistakes we police officers are doing, and defense taking the advantage of this one. So please don't make the mistakes on the chain of custody also. Okay. So these are the things that I would like to tell about the hashing, collection of the electronic and the digital records. Now I will quickly, already with 3:30, we have to go for the next class also. So cryptocurrency, I have dealt very well how to collect electronic and digital records in all the case laws, like earlier CCTV footage, cryptocurrency, computer, off condition, on condition, what to do, how to collect, on condition. So just have a cursory look. RAM, FTK, Belka software, these are the, this one, hibernate position saved automatically. Okay, mobile phones, off condition, on condition, IME number, mobile to Wi-Fi. Another thing, how you collect the mobile phones from the scene of crime? By what means you transport them? By a Faraday bag. By a Faraday bag. Why mobile phones are kept in Faraday bag from the scene of crime?
The data should not be damaged.
Okay. When you put a mobile into the Faraday bag, you need not to switch off. The moment it put it in the Faraday bag, all incoming, outgoing, all its connection to the nearest network will be banned. Wi-Fi, Bluetooth, everything will be banned. Another thing, you can put some of the devices even in aluminum foil also. Aluminum foil is something like a foil that has been used to pack the food material. They are also called as anti-static bags that prevents any magnetic communication. Okay? So Faraday bag and all those things have the pen drive, calculate the hash value, hardware tools, virus if the pen drive you obtained is having a virus, will you scan it? Original evidence, pen drive has a virus. Will you scan it? Don't scan. Okay. Properties, CCTV evidences. Okay, I will just quickly NVR. NVR means network video recorder, DVR digital video recorder, especially for the CCTV footages. Hard disk, CCTV, FSL, hard disk, scene of crime, original evidence. So it is a huge PPT. Static bags, I have told about the static bags, anti-static bags, SIM card, smart gadgets, hash value, WhatsApp, Android, chip-off method. Have you heard about the method called chip-off method? Chip-off method. Chip-off method means if the battery cannot be replaced from the original mobile, what to do? To read the memory, in forensic lab they use the chip-off method. That means they solder along the edges of the mobile, they break open the mobile, and after the battery there will be a small motherboard. Along the edges of the motherboard, again they put a soldering and take the motherboard out of the battery, out of the mobile, to read the contents of the phone, internal memory of the phone. That is called as chip-off method. Not found in any this one. This is well practiced in National Cybercrime Forensic Laboratory under the I4C, Indian Cybercrime Coordination Center, that is there next to our institute. CDTI Hyderabad, we have that capacity, chip-off method. In the CFL, National Cyber Forensic Laboratory, that method is there. Many states also have that method now. Correct procedure of chain of custody, I will not go. Cloud forensics. Okay, these are the two certificates under section 63(4). One by the owner, control, to be filled by the party, then to be filled by the expert. These are the two certificates under section 63(4). So there I end the first session, that is regarding the electronic and the digital records and the evidence under the new Bharatiya Sakshya Adhiniyam. Okay? Okay. Now shall we go for the next BNSS? Continue with the, we don't have the much time. Can you upload the next PPT please? BNSS. Yes. Bharatiya Nagarik Suraksha Sanhita. Again, a huge presentation. I will go only the important things, very, very important things. Okay? So, as you know, audio, video, electronic means bail, bail bond, bail without surety, bail bond with surety, and look at the last sentence. The definition of the victim. Now the accused need not to be formally charged. What does it mean? For example, any murder, proceeds of the crime, taken from the victim. Now you need not for the investigation to be over or the trial to be over. In the midway only, those properties can be given back to the victim. That's why it is a victim-centric clause. So the accused need not to be formally charged to call a victim. That means to say that he can get the whatever the properties or anything in the midway of the investigation or the trial. Just. Okay. So investigation, now the sequence of the magistrates you know. Only thing, assistant session judge is not there. Metropolitan, assistant metropolitan magistrates, the nomenclature has been changed. Now both in the metropolitan as well as in the rural, there will be same set of magistrates. Chief Judicial Magistrate, JMFC or JMSC. Of course, some states have additional Chief Judicial Magistrate, additional or whatever it may be. That depends upon the state. But only thing, Assistant Session Judge is not there. So the cases will be either transferred to the CJM or the additional CJM or to the Sessions Court or the additional Sessions Court. Okay. Now what are the powers? Obviously, you know, JMSC less than 1 year, 1 to 3 years FC, first class, 3 to 7 years is the CJM, above 7 years is the session judge. Whatever the penal provisions, earlier 5,000 to 10,000 is JMSC, 10,000 to 50,000 is the JMFC, above 50,000 is the CJM. Obviously, CJM can, the session judge can give any sentence, isn't it? Another thing, earlier the judges, unless and until written, the sentences used to run consecutively, one after the other. It is called by default rule. But now, both the magistrates and the judges in multiple offences has to compulsorily write whether the sentences run concurrently or consecutively. Okay? Okay. Next. On basis of the executive magistrate, now a police officer not below the rank of a superintendent of police can be designated as special executive magistrate. That means to say that, for example, there is a range headed by a DIG or an IG. Now, as like executive magistrates, now a police officer can also be called as a special executive magistrate. Why? Because there are some provisions like 107, 110, 112, 116, 117, 151 preventive detention measures. Now, earlier, the rural SPs used to ask for the DC office, but need not to ask now. Because the state government can declare them as special executive magistrate. Okay. So if police officers are there, please ensure that Manipur government has, I think they might have already passed the order regarding special executive magistrate. Next, I will not go. Public prosecutor. See, Delhi has a unique situation. Legislative Assembly, High Court, public prosecutors are appointed by the LG. Not the Home Department, not the Delhi government. That's why a lot of confusion. But now, High Court of Delhi, public prosecutors are appointed by whom? The central government. Okay. Next, 14 days notice. For example, if there is a no PP or a assistant PP for a particular case, but it is a time-bound case. Now the district magistrate can appoint a assistant public prosecutor for that case or for that period, giving a 14 days notice to the state government for the sake of speedy justice. Next, Directorate of Prosecution. You see, investigation plus prosecution. But prosecution was not uniform in the entire country. For example, Madhya Pradesh, Directorate of Prosecution was an IPS officer. Uttarakhand, IPS officer. In Telangana, Andhra Pradesh, senior PP used to get elevated as a assistant director or joint director and all those things, and Directorate of Prosecution. But now, pan-India uniformity. There will be a Directorate of Prosecution. Okay. Next, Deputy Directorate of Prosecution. And this law has created one more post called Assistant Directorate of Prosecution. Okay. What is the eligibility? Both the Directorate of Prosecution and Deputy Director should have worked as a session judge or 15 years as advocate. Okay. For Assistant Directorate, he or she should have worked as 7 years as advocate or as JMFC. Okay. Now what are the powers? Directorate of Prosecution can give his opinion on appeals to be filed where the punishment is more than 10 years. Deputy Director can supervise, monitor the cases where the punishment is 7 years to 10 years. Less than 7 years, it is the Assistant Directorate of Prosecution. This doesn't mean police officers has to compulsorily send their case study, case diaries, charge sheet to these officers, because these three officers work under the State Home Department. Only in those cases where the state feels, oh, this is a 10 years more case, let us go for appeal, revision, then these officers come into the picture. Okay. Section 18, 19, 20 deals with the Directorate of Prosecution. Okay. I have told all these things. In short, yes, already we see the magistrates concurrently and all those things. No arrest shall be made in case of an offence less than 3 years, is infirm, or 60 years without permission of the Deputy Superintendent of Police. Any accused to be arrested, less than 3 years punishment, now is infirm. Infirm means physically and mentally not so sound. And above 60 years of age, DSP's permission has to be required. Now second thing, whether oral permission? No. Because SOPs of many states have told that it is written permission. Written permission of the DSP has to be taken to this one. Although it is not written in the book, it is prescribed as it is written permission. Then, protected witness, person above 60 years of age or a person with acute illness will require to attend in any other way they reside. We will come to that one again. Remember DK Basu versus State of West Bengal. It says the grounds of arrest has to be conveyed to the arrested person. Inform the friend or the relative of the arrested person as identified by the arrested person. But problem comes when I am arresting a person out of my jurisdiction. He may tell or he may not tell. I may not found his relative or friend. So, earlier the control room was there. Along with the control room, now it says there should be assistant sub-inspector. Sorry, yesterday madam said it is sub-inspector. No, it is not sub-inspector. Not below the rank of sub. It is assistant sub-inspector. Yesterday in our PPT, please ask to change that one. It is assistant sub-inspector. Assistant sub-inspector should be there in every police station, who is called as a designated police officer. Whenever arrest has been made, that designated police officer has to be informed, and that designated police officer will in fact inform the friend or the relative as identified by this arrested person. That's why in Telangana what they are doing, they are informing to the designated police officer. They are also giving an intimation notice to the friend or the relative of the arrested person. But this relative or the friend is not at all taking that intimation notice. The moment there is a notice from the police, they told, no, I will not receive it. They think something peculiar. Oh, if I receive this, then tomorrow I have to go to the court. Even our police are telling, you have nothing to do with this one. This is only an intimation notice under the new law. Please receive it. No. They are so scary people to receive any notice kind of a thing. That's why we suggested that delete the word called notice. The moment something comes to the notice to the mind of people, they become scary. Just mention only intimation under the BNSS, so and so section. And give it to the friend or the relative in return. Okay? And also in digital means. That means so and such person has been arrested, you can put it in the SP office website also. Next, 6 hours, private arrest. Just now our Secretary Sir was telling, in Manipur, in some of the drug cases, people might hand over the drug peddlers to the police. Normally not done. As per law, 3 persons can make arrest. Police officer, cognizable offense. Second is magistrate, when a cognizable offense has been made in front of him. Third one is the responsible citizen of our country. When a cognizable offense has been made, he can also arrest that person and hand over to the neither to the nearest police station or the nearest available police officer. But there was no timeline in what time that police or that civilian has to produce to the nearest. That sometimes become illegal custody or unwarranted custody. For example, if I had to settle the scores, I got arrested from a citizen and put him in for unwarranted this one, thinking that 24 hours. And maybe in our neighboring state, Assam, it is not so uncommon of the private arrest, let me tell you, especially in India-Bangladesh border, especially with the cattle thieves. The village people, they caught hold of the cattle thieves and hand out to the police. That is quite existence in India-Bangladesh border. So now 6 hours time is there. What is the implication? Now whether the police have over and above 6 hours, 24 hours? No. Now the police officer's power to produce the arrested person before the magistrate now reduces by the time that has been taken by the private person to cause arrest. Got my point? For example, the private person got 5 hours, excluding the time taken for journey, to cause arrest and produce before the nearest police. Now how much time I have now as a police officer? 19 hours. 24 minus of 5. Second thing, whether he will do the seizure memo, arrest civil person? No. Whether he will take him to the medical? No. Whether he will take it to the magistrate? No. Everything else has to be done by the police officer only. Third thing, very important, in earlier CRPC, when a civil person hand over the person, the arrested person, and the police, it was called as re-arrest. But now, since the arrest has been made by the citizen, now it is only shall take into custody. Mind you, these are the words changed. There is no re-arrest, but only shall take into custody. Shall take into custody. Another thing, very important. Please.
In that case, what about the arrest memo, sir?
Police officer has to make. Police officer has to make arrest memo. Remember the Sunil Batra case and the handcuff case. Remember the parliament attack case, where some of the advocates gone to the Supreme Court and the various lower courts also, seeking that let the police take the permission of the court even to handcuff so-called notorious criminals. Isn't it? So there was ambiguity in which cases handcuff has to be done while arresting or taking into the police to the courtroom. But now it is simple. Three grounds. First, nature and gravity of the offense. Whether he is a notorious criminal, like in Nigerian frauds and all those things, they are very, very well built. They can easily overpower some of our constables or something. Nature and gravity of the offense. Repeated offender. Third, if he has escaped from the custody earlier, either judicial or police custody. In these cases and in these offenses, the police officer can handcuff. What are the offenses? As I told, organized crime. Section 111. Not 112. Section 112 BNSS is petty organized crime. It refers only for organized crime. Then Terrorist Act. What is the section? 113. Next, drug related crime, NDPS cases, illegal possession of arms and ammunition, Arms Act, murder. What is the new section? 103. Rape, section in BNS 60, 63 and 64. Rape. Sexual offenses against children. Which chapter in BNS? Chapter 5. Now sexual offenses against women and children are clubbed in together and come in chapter 5. Okay. Next, acid attack, counterfeiting of coins and currency notes as per the 1976 Act. Now it is deleted from the BNS. Then human trafficking. Anti-human trafficking. About to be person. Carefully see the section. Carefully see my PPT. There is a word called about to the person. That means to say that any offensive weapon that is there with the pockets or with the custody of the person. Now immediately seize the weapon. Now what is the idea behind this? Because when I am searching a person, accused person, if I am so very legally bound, means what I will do? I will offer my body search first. Then he has a chaku. He put a chaku to me only. Or there are some notorious criminals. What they do? They hide some blades here and there. Either they tore off the police officer or they tore themselves. They make damage for themselves and put the blame on the police. Sir, देखिए ये police officer है ना, ये अरेस्ट करते समय क्या किया? ह्यूमन राइट्स वायलेशन किया. isn't it? So, immediate seizure of the weapon while causing arrest. Okay. Medical practitioner shall without delay. The word shall has been added. There are two ways now. Medico-legal cases or medical examination report. In ordinary cases, shall without delay, you have to give the medico-legal report. But in the rape cases, it is 7 days. There are 35 timelines prescribed in the Bharatiya Nagarik Suraksha Sanhita. 35 for speedy justice. I will come one by one. One of thing is that within 7 days, 6 hours is also one of the timeline. Within 7 days, this shall without delay. Another thing, additional medical examination. If the doctor says yes, I will give one peculiar case that happened, that is Telangana. A girl came. She says that I am getting stomach pain, please examine. Doctor says you are pregnant. Are you married? Girl says yes, I am married. Ask her parents, who is her husband, whether she married. Parents say no, because she has some friendship or something. Now she came after 2-3 months. Now how to find out? Now the doctor prescribed for additional medical examination to find this one. Now those poor villagers, they put a blame on the doctor itself. Why you are asking for medical examination for her? No, I want to test her and what is the thing and all those things. I want to see that one. That is my duty. Even MLA called. This is a kind of a sometime politics, because they were also asking what is the status, what is your position to ask for a medical examination to the doctor itself. But now it is not there. If the doctor says no, I want to conduct additional medical examination, nobody can object. Now another thing happens also in some of the rape cases. Or what happened? Boy and girl get into a relationship. Girl get into a pregnancy. She put a complaint. Now, if then both the side comes, then they will say, sir, don't register, no investigation, nothing. If they are minor, we will ensure that they will get married when they are get into major, or if they are major, we will get married. Don't put up anything. Now what the girl says? Okay, she will not cooperate with the investigation. The case becomes weak, thinking that the boy will get married to her. Having seen that the girl is not cooperating or retracting from the earlier statement, this boy later refuses to marry her. These are the cases happening now. Reality. If you ask the doctors, they are telling these things. Now, where the police go? So, these kind of situations also exist in the society. Okay. Additional medical examination. Next, 63, summons. Earlier, summons can be, it says that adult male member of the family. Above 18 years, male member, family definition you know. Servant is not considered as the family member. Because old laws, there are some communities where the woman does not come out of the house. Pardanishan women, burqa women. That's why they kept out of the purview of issuing summons to the lady. But now things have been changed. Now the summons can be issued anybody, gender neutral. And even by electronic means, very important. Now, that electronic copy should contain the proper signature and seal of the court. Number one. Number two, a register has to be maintained in the court as well as in the police station for mentioning the names and addresses of all those cases where the summons has been given electronically. These are the things that has been changed in section 63, the issuing of the summons using electronic means. Okay. Next, gender, women, adult member, now already discussed. Duty on police officer, forthwith give information, ASI already discussed. And proclaimed offender. Earlier there was no proper definition. Now under section 84(4) of the Bharatiya Nagarik Suraksha Samhita, any offense which is punishable for more than 10 years, you can issue a proclamation notice. Okay, that is very much there in this one, 10 years or more. Superintendent to initiate the process of requesting assistance from the assisting state. This is called as laterogatory or investigation abroad or collecting the evidence from the assisting state. Assisting state means, or assisting nation means, or assisting country means where India has signed Mutual Legal Assistance Treaty, MLAT. According to it, any fugitive offender has gone to that country means we can extradite him. Earlier, the process was cumbersome. Take the permission of the court, write to Interpol, which is there in CBI 6th floor, then MEA, embassy, then go to foreign embassy, from foreign embassy to our embassy, from there to chief secretary or DGP or blah blah, whatever the hierarchy there in the foreign country. Many of the cases, the investigation abroad have not been this one. So we were not getting any evidence. But now SP or the Commissioner of Police can initiate this process. Okay. Attachment or forfeiture of the property belonging to a proclaimed person, proclaimed offender. Okay. Next, 105. So lot has been spoken about 105. Audio, video, electronic means and using this one. That's why the Telangana police have made a beautiful SOP. We know that the entire process of search and seizure cannot be videographed. That's why they made this one. First 1 minute. Take introduction of the parties, introduction of the independent witness, explaining, show the search warrant, offer body search. Then whatever the materials you can, this one, collect it. Signature, this one, so that it is minimal. Mind you, very important for both judges as well as officers. Now the seizure video will become a part of our final report. That is the charge sheet. It is bringing more challenges for the police officers now. Earlier, what you used to do, police officers mostly take all the documents from the scene of crime. Then where we will take it them, go to the police station, then segregate what is required, what is not required, prepare the seizure memo there, call the witness, and sometimes even the witnesses are just our neighbor chai dukan wala. Just on a funny side, you know, na? So these were things were happening, might be happening, but now it is simple. And one of the thing, very important basic thing is that, what is the basic mistake that the police officers do when go for search warrant, search places? They do not do offer body search. The moment I go for searching, first I have to offer my body search. Because it is very easy to put a pen drive here, some narcotics, and place it in the house, bedroom. And later, oh, I found this one, that one, this one. That's why there is always allegation that police have implanted the evidence. Isn't it? Now, putting end this one, now what you have to do? Compulsorily videograph the search and seizure. Having said that, it will become a part of our final report under 193. It brings more challenges. Now the lawyers, defense lawyer will open this videography and say that, sir, you know, they have not followed this procedure, they have not followed this procedure. Because in search and seizure, it says that the inmate of the house has to compulsorily accompany the searching team. Is it? Second, no human right violation should be made. Third, as far as possible, the decency and the order of the objects in the house should be kept intact. Isn't it? Now, we have to take a lot of caution while doing the videography. Whether you keep everything ready, then videograph, it is up to that one. Moreover, the videography that you make will be automatically uploaded in the eSaksha app, where you share the link of the e-Saksha, that video, to the court, to the accused. So no need of worrying of taking pen drive, downloading this one, because it is a cumbersome method. Because here we have 1 or 2 police stations. In UP kind of a thing, in one district there is 30 to 45 police stations. Even if they go for one search a day, can I take, go for every day, can I go for with a fresh mobile phone? Or shall I go with a fresh pen drive every day? 45 pen drives every day? Even one police station into 30 police stations. Moreover, our search may conclude for 3, 4 hours, 5 hours. Then shall I take so much of hard disk? Not a practically possible. That's why e-Saksha app is there. So download from, that is made by the NIC, National Information Center, and use that app as early as possible, and ensure that our judiciary or police department are good in using, sharing, and also the judges need to appreciate this e-Saksha app. There is another app called Nyaya Shruti. Please note down. Nyaya Shruti. Nyaya Shruti by the NCRB. That is also a good for the evidence. There is another app called E-Sankalan. E-Sankalan. That is an app created by National Crime Record Bureau, which says about the old law, about the new law. That is the new, this one. And lot of material you will get it from our own department. That is, since I am from the BPRND. Yesterday, madam was telling, no, all SOPs, we saw this one. We have uploaded lot of SOPs, lot of e-modules, everything on the BPRND website. Bureau of Police Research and Development. That is our organization. There you get lot of videos, lot of material on the new criminal laws, and lot of SOPs also. SOPs, yesterday madam was telling about 76 page on the search and seizure, this one, that is from our organization only. So go and visit the website and all those things. Apart from this, please visit CDAC website, website, because there are so many online courses like Chariot, Side Train, Meg Shikshak. These are the good courses both for the police officers or judicial officers to train yourselves on cyber crimes. www.cytrain.gov.in. Cytrain, C-Y-T-R-A-I-N. Cy stands for cyber. Okay? Go to CDAC, Center for Digital and Advanced Computing. CDAC Hyderabad or CDAC Hyderabad is also there. There you find Chariot, C-H-A-R-I-O-T. There is a educational this one, where you get lot of training. Go to Mega Shikshak. Make Shikshak under the CDAC only. There you will get again some of the course. And another one training module, training course that has been developed by BPRND is E-Ustad. E-Ustad. U-S-T-A-D. Ustad means what? Teacher. So it is e-teacher. So there is a lot of things already available with many of the organizations. Okay, we can learn better, aram se in our office, we can learn a lot of things on cyber crimes, get training, you will get certificates. Unlike in other websites, unless and until you pass the each course, it will not end. That makes sure. Oh, I will just flip all these things. Later, I will download. No. So we have taken the practical this one, how our police officers do. Okay. So make use of these tools that are being available online, but especially by the Government of India. And there is Astra, A-S-T-R-A, Astra, by C.Dot, Center for Digital and Telecommunication. There you can find which SIM is the fake SIM and all those things. C.Dot has nullified almost 1.5 crore kinds of SIMs across the state. Astra is also a software. Oh, okay, I'm running out of time. Okay, Astra is also a software which helps in many other things. Visitor Assistant Register, ANPR, NAFIS, and all those things. Okay, chalo. 107, attach, forfeit any property obtained as proceeds of crime. This is what I am telling. The accused need not to be formally charged for a victim. Now, how it happened? 107. This is a brand new section, especially for the judges and the police officers. Forfeiture of the property, attachment, even during investigation. Procedure what? Take permission, SP or CP, application to court, court issue notice to the accused. Then, or whoever the property is there, ex parte order is also can be done. Proceeds of the crime can be ratably distributed to the claimants. Of course, now some questions are there. Give 60 days time to the district magistrate and ratably distribute the proceeds of the crime, even during investigation. Now what happened if, now the question is why it is sub judice, later the acquitted, later if you find that the property does not belong to the claimants, that is there. But if we go to the verbatim of this section 107, sufficient take care has been made both by the police officer as well as the judiciary in releasing this property. Next, maintenance of wives and children, parents. Parents is the new one added by the government. Now, if the parents want to claim compensation or maintenance from their children, they need not to go to the place where the children are residing. They can put up a petition here only, irrespective of where the children are staying. That is the idea behind this section. Deputy Commissioner of Police can also deal with in case of public nuisance. CRPC prohibit, now I will not go. 172, for example, if any person is refusing resistance to the bona fide directions of a police officer, arrest him 24 hours, release him, mentioning it as a petty case. Okay. Next, filing of 0 FIR and EFIR. 0 FIR, you know, beyond the jurisdiction. Earlier was also there, but it was not under statute. Now, Manipur, crime happened here, but you are traveling to Delhi. Go there, put up a FIR in any of the Delhi police station. They will send that copy to the concerned police station in Manipur. Or EFIR. Even if in Delhi, you can submit a EFIR for a case to be registered in Manipur. There the police station in the CCTNS, Crime Criminal Tracking Network System. Now NCRB is coming with the second version after this one. CCTNS 2, where these all new items are there. There you go, choose 0 FIR, mention all this one and send it to the concerned district. But only thing, CCTNS, they are not giving all the details of the police station. They are giving the districts. For example, if I had to send it to district of West Bengal, they are not, for example, in Burdwan district, what are the police stations, they are not mentioning. That is the only thing. Of course, you can send it to the SP. They will decide. Okay. 0 FIR, EFIR. There is no word mentioned called 0 FIR or EFIR. In the first sentence 173, it says, irrespective of the area. Have you observed it? That says that is 0 FIR. Complaint even by electronic communication. That means EFIR. 173.1, the substance of the complaint has to be mentioned in the particular report, particular book referred by the state government. These are the words there. There it means GD. Whereas in 173 it says, a copy of the information that has been recorded under 173.1 has to be given to the victim, to the complaint. There it means FIR. Don't make confusion. 173, 0 FIR and EFIR. Okay. Okay. Cognizable offense, commission of this one not signed, 3 days and all those things. Yesterday I told the procedure. If not come with 3 days, if later they come, then what is the procedure? First you treat it as information, send the police officer verification report, then you can register an FIR. This is not new. Earlier also dial 100 was there. Electronic communication. So in a way it is not such novel. Okay. SP, now another thing. Police station did not register case. Law says for police station you can send electronically. But for police SP, you have to send it by either by post and a written complaint only. Now question asked, why written complaint only? Because the SP has to make sure that there is a person behind the complaint. Second thing, you can send it by post. That also means that the person can go and meet the SP in person and give the complaint. Okay. Now, if SP also does not register a cognizable case, then that person has to approach the magistrate with an affidavit. Why affidavit? Otherwise, falsely he can plead. He can make an affidavit that I have met SHO, SP, all these things, and cognizable offense. And now the magistrate can ask an explanation from the SP. Why you did not register a case? So that is all there. Okay. Now complainant, victim, accused all get the copy of the FIR. Then preliminary inquiry, 3 years but less than 7 years, cognizable offense. Now take the permission not below the DSP, again return permission and go for a preliminary inquiry. Okay. Making application even if FIR is not registered. Okay. Non-cog offenses, yes. NCR cases, earlier no FIR, but dispose of the case. But now, even in non-cog cases, 15 days once, all the non-cognizable offenses report has to be sent to the magistrate. Once in 15 days. Why? Because the magistrate can see whether there was a chance of registering FIR in the police station, but the police did not act. They just sum up the clause by making it as NCR. That's why. Especially in matrimonial cases, husband and wife jagda karte hai, police station aata hai, then police will, okay, both will come and they just solve the matter. What happens if there is a beating by the husband to the wife? So these all cases come into the picture. Now 175(3), this is what I was mentioning in the morning. 175 allows the SP to depute DSP rank officer to conduct the investigation. Depend upon the nature and gravity of the offense. Morning I was telling in the madam's class. Then 175(3), examine application. This already I told. Protection against false and frivolous cases against the public servants. Good news for public servants. So if there is a false and frivolous cases, earlier what used to happen? Either FIR or departmental inquiry used to happen. But now, when a false or a prima facie a false or frivolous case against us has been made by a private person, then ask the officer in question to explain the assertions of the case. The word assertions is there. For example, I am controlling a mob, but I exceeded my lawful duty. I may be asked, sir, what are the circumstances that make me to this one? Also, seek a report from the superior officer. That is, if I am DIG, then ask from the IG or whoever had deputed me. Next, place of our choice in for rape victims, presence of our parents or guardian, relatives or social worker of locality, preferably by a woman police officer. Now she can choose to give her rape victim anywhere she likes. 7 years or more, any offense 7 years or more, compulsorily take the forensic team to the scene of crime for proper handling, collecting, transporting, preserving, identifying the evidence. Okay? So 7 years and above. But all states are not equipped. That's why states have given 5 years time to prepare themselves for a better forensic facility to comply with the earlier provision. Next, these people need not come to the police station even during investigation for giving their statement. Who are those? Male below 15 years, women, physically handicapped, above 60 years of age, acute illness person. These need not come to the police station to give the statement. Then, judicial magistrate whose district the offense has been registered, he is made competent to record the confession or statement. Now, this is another one. Earlier section 161, now 180. Earlier 164, now 183. Confession. Now the question comes. See what changed. In section 183, earlier the word judicial magistrate was there. But now in the new law, the judicial has been taken off. That raises the question whether any magistrate can conduct confession. No. You have to read section 183 with the last sentence. That is the section 3. Magistrate means only the judicial magistrate, either of the first class or the second class, where section 3 says construction of references, unless the qualifying word says magistrate means either the judicial magistrate first class or the second class. So that means to say that in section 183, anybody having the book later, you see in section 183 the word judicial is not there. Whereas compared to 164, the word judicial was there. Okay, but still it means that judicial magistrate of the first class or the second class. Okay, these are some of the things I have this one. Next, 10 years. This is a very peculiar section where there is an option for the police officer, no option for the magistrate. Any offense punishable more than 10 years. Now the police officer can take as number of witnesses or persons to the magistrate to record the statement. The magistrate shall record. Look at the sentence. Look at the word shall. What does it mean? Here there are 10 accused people or 10 people of my case. Witnesses or whoever it may be. Now what I will choose? I will choose her, I will choose him, I will choose him. Only 3 out of 10 and produce before the magistrate. Please record their statement. Now the magistrate shall compulsorily record their statement. They cannot ask why you did not bring another 7, why you choose only 3. No. This is a very peculiar provision where in heinous cases let the prosecution build up their story. That is the idea behind this legislation. Protection victims of rape, preferably. Now even in the court for the lady, only lady, preferably lady magistrate has to record the statement of the rape victim. Next. Registered medical practitioner, 7 days already this one. Search, case diary and audio video already we discussed. Another thing, you have to send the search report within 48 hours to the concerned magistrate. One more thing. The search report, there it is said, yesterday madam forget to tell. There it is said DM or SDM or JMFC. Okay, JMFC I agree because there is a case and you send the search report. But why DM and SDM? Earlier it was not there. Because while going for search you may have found some unclaimed property or a property not involved in any of the case. In those cases obviously you have to produce to the DM. Next, custody, police custody. Already you know the 15 days police custody remains the same. But that 15 days can be taken either in whole or part by part within 40 days for a cases to be investigated in 60 days. That means cases which are punishable less than 10 years. 15 days of police custody can be taken in parts or in whole in the first 60 days for a cases to be investigated in 90 days. That means cases punishable for more than 10 years. Look at the section, this one, 15, 40, 60, less than 10 years. 15, 60 days for 90 case investigation period for the above 10 years punishment. So if you see this position, then you will not get confusion. Okay, just somewhere you can note it down for the better this one. Next, 187, detention shall be only in police station or the wherever the this one like jail or lockup. Next, 15 days otherwise. Another 187. while forwarding to the judicial custody, the earlier CRPC says otherwise than in a police custody. But now the words otherwise than in a police custody has taken off. Now the question comes whether the police custody can go more than 15 days. No. It can be taken in first 40 or 60 days, either in the whole or a part. That's why in section 187 it is clearly mentioned not more than 15 days of police custody. So need not to be this one, because there are a lot of YouTube videos which are putting unnecessary confusion among the people of our country. Okay. Next, such custody and such custody may be concluded as police custody. This is another thing, especially for the UAPA Act, this one. See now, for beyond transnational crimes, three things. One, first the word India has been taken off from the Bharatiya Sakshya Adhiniyam to give the jurisdiction beyond India. Second, section 48 in the Bharatiya Nyaya Sanhita added where it says that abetment to commit an offense made outside India for an offense to be committed inside India. Section 48, especially for cyber crimes. Added with this section 208. Okay, that is there. Where the offense is registered in India is also added. Next, previously accused was not custody. Now, initially when you arrest the person, take to the magistrate and produce him. For re-remand, for further police custody, you need not take the accused before the magistrate. Just show that he is there in the lockup and seek fresh custody. Extension of the police custody. Okay. Next, 193, you can file it in electronic means, all the charge sheet, final report, everything, you can submit it electronically, e-filing to the courts. To make law more victim-centric, 90 days. That is the cases heinous offense, about 10 years. 90 days you have to inform about the progress of the investigation. Progress means substantial progress made, like arrest of the accused, submission of the charge sheet, like this. Next, process supply of copies. Earlier there was no timeline. Now within 14 days the magistrate caused to give the copies to the accused. Usually the police will take a copy and give it. Now what we can do? Make a pen drive, give a copy to the accused, or send it by email, the charge sheet. Okay. Final reports, okay, 90 days, already I told. Further investigation has to be completed within 90 days. With the permission of the court, trying the case completed within 90 days. Obviously, POXO case and rape cases, timeline is 60 days only. That remains the same. Okay. Any suicide happen in the district, within 24 hours, inform the DM or the SDM, because they are the persons who can order for the inquest. Okay? And with presence of two local inhabitants. Then these are the things, they need not to come to the police station, already I told. Committed outside India, section 208, I already told. That means any exhibit that is there outside India, some proceeds of the crime, some building that is there in London. Now you need not to go physically to investigate. Ask the police officers there to send a photograph or a video of that evidence. That itself is sufficient to go ahead with the trial here in India. That's what it says. Electronically you can get the evidence. Then delay cost 120 days. See, prosecution sanction, very, very important. Now, unless and until the prosecution sanction is not given within 120 days, it deemed to have been given. So the blanket, protective blanket above our head is now over. Okay. It deemed to have been given. Next, cognizance by magistrates. Very important for the judicial officers. See, cognizance taken by the magistrates in 4 occasions. You know that on a police report, otherwise than on a police officer complaint made, that is by the accused regarding torture or what. Third, by a private person, or a cognizable offense has been made in front of him. These are the four situations where the cognizance has been taken by the magistrate. One of the important thing is that complaint made by the private person to the magistrate. That is section 200 of the CRPC. Now I will explain very clearly. Earlier CRPC says, when a complaint has been made to the magistrate, magistrate shall cause to summon the complainant, examine him on oath, and finish. There he can decide whether to send it to the police officer for investigation or close the case. Because even Supreme Court judgment says, the moment the magistrate examines any person under oath, it means taking cognizance, isn't it? But now it has gone ahead now. What it says, a complaint has been made to the magistrate. Now not only he called the complainant, he called the accused, the prospective accused, the notice. Now the accused can come alone or with the advocate. He can come up with the oral evidence or documentary evidence. Now the magistrate has to compulsorily examine the accused also. So now most of the magistrates are telling, already we are burdened with a lot of work, LPC, long pending cases. Now this will increase the burden of the magistrates. Calling the accused, 15 days notice, isn't it? So obviously the idea is that instead of delaying the matter, let the matter be end there at the maximum at the end of the magistrate. But what is the problem? It will increase the burden of the magistrates. Okay. CJ may also, now confusion. Section 200, these were there, but now that was there. Then, in order to strengthen opportunity to the accused, yes, complaint cases, protection for false and frivolous cases against public servant. Already we saw that one, 223. Special summons, petty offenses. Now the monetary limit has been raised from 1,000 to 5,000. Petty offenses. Then fine also raised from 1,000 to 5,000. Next, of course, MA Act doesn't, this one, apart from MA Act. Because in MA Act, even if you don't give sight to the ambulance, how much fine? 10,000 is there. So MA Act does not come into the picture. Next, issuance of process, electronic means, supply of copies to the police report, 14 days. I will again quickly go through. Police report, magistrate shall without delay was there, but now it is 14 days. Commitment of the cases. Now another time period. Now the committal proceedings has to be finished within 90 days. Extendable to 180 days with reasons recorded by the magistrate. Now magistrates also has to write the reasons recorded for delay. So time allowed for committal of the case is 90 days. In one way good, one way bad. Because committal of the proceedings may not take 5 days or something unless the accused is needed in many of the cases. Now what the magistrates will do, oh there is 90 days time period, let us take on 85th day. Let us finish off these cases. That also is a possibility. Next, another thing. 60 days from the date of committal for a discharge application. Very good thing. For example, in a case, there are 4 accused. A, B, C, D. What they were doing earlier? A will come. You will put up a discharge petition in the trial court. Dismissed. You will go to the session court. Or you will approach the high court under 482. There. Then after A finishes, who starts? B. Then after B, C. After C, D. Like this, these accused will gang up together to delay the trial for many years. Am I correct or not? Isn't it? But now, that is not the case. In committal of after the committal of the case, how many days is there? 60 days you have to submit the discharge petition application. If you have to submit. Okay? Next, offenses of same kind Earlier 3 offenses of same kind can be this one, but now it is 5 offenses. Okay. Judge shall frame charges within 60 days. Framing of the charges. Now the entire proceedings of the framing of the charges has to be completed within 60 days. From the first day of starting the charges. Okay. You need not to ask the accused to be present in the court. That is another thing. Because want of accused only is the delaying cause. Now ask him to produce via audio video means and read over the charges and frame the charges. Even he is absconding, proclaimed offender, designate a lawyer for him, go ahead with this one. That comes trial in absentia. Next. Use of audio video means expert witnesses and public servants. Now you and me need not to go to the court to give our evidence, nor a FSL expert. Now via audio video means public servant, expert or any officer can give their evidence via audio video means. Okay. Next. Even for giving judgment. Now the session judge has to deliver the judgment within 30 days after the last date of hearing, extendable up to 45 days with reasons recorded in writing. See, 30 days deliver the judgment. For other cases, not later than 45 days. You have to deliver the judgment from the last day of this one. Third, the judgment copy has to be uploaded in the website within 7 days. Many timelines are there in the BNSS. Okay. Next, trial of warrant cases. Discharge petition again 60 days. We deal with evidence, prosecution, the examination of witness along through audio video means. Yes, warrant cases again 60 days. I will not go again cross-examination, but it is not practical. What does it say is, for example, the examination is done by the prosecuting officer, PP. But the defense is not ready or the defense lawyer is not attending the court. After giving sufficient opportunity for the defense lawyer, the judge or the magistrate can dispense with the cross-examination by the defense lawyer and go ahead with the examination in chief, if it finds that the defense lawyer is making unnecessary delay. But it is quite impractical because these lawyers, they will approach the higher forum and say that, sir, we are not given sufficient opportunity to cross-examine. That's why the magistrates and the judges are of the view, sir, let him take one more chance, 1 or 2 more chance, rather than he approaching all the higher forums and again my case will go for another 2 months. Isn't it? This is the practical difficulty that we face in the courts. But anyway, for the speedy justice, this is the best method. Then 30 days non-cog offenses compoundable if the complaint remains absent. For example, a complaint came to the magistrate, which is non-cognizable and compoundable. But the complaint, after submitting the complaint, is absent for 30 days. Now what to do? Why to harass the accused? Close the case altogether. That prevents some of the frivolous cases, settle the score cases kind of a thing. Isn't it? Next, summons trial. Magistrate consider accusation as groundless, he can discharge. So again, death of a complaint. Magistrate can give 30 days and close the case. Plea bargaining. Very important. Plea bargaining is only for the cases which are less than 7 years, not punishable with death or life imprisonment. What magistrate take cognizance, examine complaint, accused file plea bargaining, application in brief. These are the things, notice to PP and all those things. Here, there are 2 timelines. 30 days. 30 days time is given for putting a plea bargaining, this one after the charges have been framed, where cases less than 7 years. Okay. And 60 days time is given by the magistrate to go for a mutually satisfactory disposition where PP, police officer, accused, complainant will sit together, decide what compensation has to be given to the victim, what is the minimum punishment to be given, and close the case. Of course, it is not a success story in India, isn't it? Is plea bargaining a success story in India? No, because they always have in mind that no, you will get acquittal. Okay, anyway, this is the case. Notice to the PP, then disposal of mutually satisfactory, this one, of course, admonition and probation, Probation of Offenders Act and all those things come into the picture. And what is the new thing? If it is a first time offense, minimum punishment has been prescribed. Then in plea bargaining, he will be given in BNS, then half of such minimum punishment will only be given. Okay. First time offender, then 1/4 of the punishment. Offense, accused, plea bargaining, half of the punishment. First time offender, only 1/4 of. If there is no minimum punishment prescribed, then 1/6 of the punishment. 1/6 of the punishment. If this one, 1/4 of the maximum, or 1/6 if there is. So this is a new provision under the plea bargaining. This says for the first time offenders, lenient approach is there. Isn't it? Next, I will not go these details. Summary trials, right in summer, all the three summary trials again 3 years. Then within 3 days, plea bargaining by accused, 30 days from the framing of charges and 60 days for mutually satisfactory disposition. 293, plea bargaining, I already explained. 1/3, 1/2, 1/4 of the punishment and all those things. I will not go this one again. Evidence inquiries, advocate through electronic means. Yes, dispense with this one. Now you have taken the statement of the accused via video conferencing. Law says within 72 hours take the signature of the accused who has been examined via video conference. Simple. 30 days has been introduced. Challenge genuineness of the document. Any document come to the court. If either of the party does not dispute for 30 days, it deemed to have been admitted. Simple thing. Again, new provision. Any document, public servant. Another thing. If the officer in question could not attend to the court, despite efforts, then his successor in the office can attend on his behalf. Under what circumstances? See, transferred, retired, died, cannot be found, incapable, he is not bedridden. For example, in Manipur and Nagaland, this happens. Assam Rifles come, put up a case under section 384 extortion. When it comes for trial, whole battalion or whole company has moved out, it is very difficult to trace them. Do they come and deposit the witness statement? Very hard to keep. Now what we can do, at least he can be examined via audio video, or his company is still there, his successor can be called into the court. This is very fruitful, especially for our northeastern states. This successor in office and audio video means. Next, curtail delays, framework may grant more than 2 adjournments. See, now only 2 adjournments can be given to the either of the party. Again, quite difficult to implement. Beyond circumstances, when there is no opposition from the other party, only adjournment can be given. Otherwise, only 2 adjournments can be given nowadays. Or impose cost on whichever the party is not ready to examine or not ready to come over, isn't it? That is the best thing. Power to postpone without examining them, no adjournment. I already, when the witness is present but a party advocate not ready to examine, the court may record the statement of the witness as things fit. If another party does not come, then dispense with the cross-examination. Magistrate of first class direct any individual specimen. Without causing arrest, you can get the specimen sample, be it voice sample, fingerprint, whatever it may be. need not to cause the arrest. Earlier we need to cause the arrest, but now no need to cause the arrest. But provided he has arrested somewhere earlier. Fugitive criminals, trial in absentia. I will give in brief. Now 356 is a new provision, trial in absentia. For example, a proclaimed offender has been absented. Now what to do? Within 90 days time, the trial cannot be started. Why 90 days? Within that, a 2 notices has been issued to the proclaimed offender. Publish in the newspaper, local and all that. Inform the friend and relative about the trial has been started. Then, from framing of the charges till the judgment, the person can be heard in absence. Now what to do? Only the magistrate has to appoint a lawyer for him from the DELSA, District Legal Services Authority, and this one. For example, that person is sitting in London. This lawyer takes care. And in his absence, even sentence can also be heard. Not only framing of charges, everything. That is a new provision under section 356, trial in absentia. Okay, sentence has been given. To appeal in the higher forum, he has to come in person. Okay? That not mean that sitting in London he can manage everything. No. That is there in this trial in absentia. So 90 days I have put up in a very smart, only one few sentence. This is the thing. New provision, this is the thing, later you go, this one. 30 days, affix in house, display, all I will not go in detail. DELSA, trial, mobile and withdrawal of prosecution. See, politically motivated cases. Any party come, they will take out all the cases that has been registered by the earlier this one. But without hearing the victim, now withdrawal of the prosecution cannot be done. Next, victim-centric withdrawal of the prosecution. 366, in-camera trial, even for POXO cases. Earlier it was only for rape cases. Another important. Now, giving false evidence, it has been increased to rupees 1,000 and with 3 months imprisonment. Earlier it was only 500 rupees fine for giving false or fabricating evidence. Now it is more stricter. Lawful authority, take cognizance before rising of the court. I will not go into the details. Co-accused custody may be produced through audio-video means. Again, translation of a copy. It can be given to either of the parties. Now earlier it was only for the accused. Court death sentence, forthwith. The idea of forthwith means as soon as possible. Has to send to the High Court. Okay? For confirmation. Witness protection scheme. You might have seen some of the cases. Like one same famous film actor case who run in the midnight. There is one Asaram Bapu case where the witnesses were mysteriously missing. Isn't it? Mahendra Chawla versus Union of India case. Supreme Court stated that they also come up with a draft witness protection scheme. Witnesses are either tortured, harassed by this one. Law Commission also says, Malimat Committee and all those things. But now, for the first time in BNSS, witness protection scheme has come. Okay? Malimat Committee and Mahendra Chawla Committee and various law commission reports. Now, these are the things, and what are the things? I will tell it in brief. The witness protection scheme has to be notified by the state government. There should be a witness protection fund allotted by the state government budget. The SP or the Commissioner of Police has to categorize the vulnerable witnesses into 3 categories. A, B, C. A, where there is a life threat. B, property or his relatives or something else. C, harassment, induce, coercion and all. Like this, the threat analysis report has to be prepared by the SP or the CP. Now, what are the measures? Measures include proper escorting to the court, giving patrolling around the house of the witness, changing the identity of the witness or the victim, like in the Nirbhaya case, like in the Abhaya case, whatever it has come nowadays, and also giving the alternate accommodation if the witness. So these are all there. They are giving new identity, close protection, providing police escort, already I told. Okay, these things are there. Then petty offenses, 6 months, 1,000, now 3 months to 1,000. Now frivolous petition, applicant to say such sum, I will not go, 472. Mercy petition, there is a time law. When the mercy petition come there, or accused, life sentence, death sentence has been confirmed by the Supreme Court on an SLP. Now accused has two options. Approach the governor or the president within 30 days after the SLP was dismissed by the Supreme Court. Okay, he approached the governor. 30 days time. Governor said no. After that, the accused can approach the president, but within 60 days. Central government has to give its recommendation, advice for the president within 60 days. See the beauty of this law. The central government has put itself a timeline for a speedy justice. Fourth one, there will be no further petitions or appeal once the final verdict has been given by the president. Because you see in the Ajmal Kasab cases and all those things. In the midnight, they open the Supreme Court and all those things. I will not go into the details. So now, another thing. The jail superintendent, it is his duty to tell to the accused, okay, death sentence confirmed, but you have a constitutional right of approaching for mercy petition before the governor or the president. Okay, there are A, B, C, D. Out of that, only 2 applied. But it is the duty of the jail superintendent to send the records of the other 2 also. Names and address. Why? Because either the governor or the president can understand the whole case and see whose part is how much in the crime. So that accordingly they can decide upon the mercy petition. Hope it is understood. It isn't? The duties of the jail superintendent and the timelines even in the mercy petition. So I have tell it in all the things, constitutional provisions and all those things. When the president office informs about whatever may be the case, within it has to be informed within 48 hours. Again, another timeline. I will come to the end of the presentation almost. No other petitions are received. This one, he required to forward the names, records and all those things. This again. Applicant pays such sum. Sorry. Another thing. Without the consent of the accused, commutation of the sentence is possible. Life to life, death sentence to life sentence to 7 years, 7 years, and 7 years to 3 years, 3 years to fine, or rigorous to simple. Without the consent of the accused also. It can be done if the state government feels so. Next, bail under trials for first time offenders, released on bail. 1/3, this one, if involved in more offenses not released. First time offenders, bail provisions have also been changed. Make application, of course, as soon as they complete 1/2 of the or 1/3 of the punishment, they are eligible for bail now. However, it is only for other than the punishments which is life sentence or the death sentence. But only exception is that if a child is involved, even the offense is of life sentence and death, the child could have the bail. Earlier it was 16 years, but as per BNS, now the child is 18 years, male or female. That is in the next slide. 7 years are convicted, 3 to 7 years, child, now child replaced by 18 years. Okay, 497, quick disposal of case properties even during investigation. Again, accused need not to be formally charged. What is the procedure? 14 days. It is good for the magistrates. 14 days, you take the photograph or the videograph of the exhibit are the property, proceeds of the crime. Property has been photographed, then within 30 days, the court shall within 30 days after the statement prepared, order for disposal, destruction, confiscation or delivery of such property. This is another timeline for the disposal, destruction of the property. Of course, sometimes the natural decay and perishable goods are there, isn't it? 497. 530, last but one section, it says all evidences, all procedures, search warrant, searches, audio video means can be conducted through electronic means. This is one of the founding pillar to conduct everything, audio, video, electronic we are telling, no? Section 530 says. And section 531 is the last section in the BNSS, that is which says about the repeal and the savings. I will tell one thing. Whatever the cases registered before June 30, IPC plus CRPC. Offense happened before June 30 or 11:59, but offense came to the police station after July 1st. Then IPC plus BNSS. Second. Third. Offense happened at 11:30 midnight of June 30. Girl kidnapped. July 1st morning 1 o'clock she has been raped or murdered. Now it is called as a continuing offense. So the new section is BNS. BNS plus BNSS. Any doubt? Because this is the one creating lot of people. People used to call me also, sir, what to do. So now it is clear. Offense happened but come to the police station after July 1st. IPC plus BNSS. Continuing offense, if it extends to the July 1st, then BNS plus BNSS. Okay? And another thing, sir, somebody has cheated me in 2020, he has to give him some money, and now also he has not given. It is not called as a continuing offense. Continuing offense means 120B or something like that, where it occurs this one. There is we can correlate between this one. One offense happened 1 year back, now again, no. Now we cannot say that one. For example, 2023, somebody owed the money for me. Now I called him, he slapped me. No, that is not a continuing offense. So now the fresh offense has to be taken into consideration. So these are some of the doubts regarding the repeal under the savings, when to use which section or the which law and all those things. Isn't it? So already I exceeded the time by a very, very large amount. Sorry for the exceeding the time. So I don't know whether to receive some of the questions. We have some time, or I don't know. It is moderator our judge will decide now.
Thank you very much, sir, for your wonderful presentation.
Thank you so much for patient listening.
So now, due to paucity of time, only 2 questions may be put to the resource person. Only 2 questions.
Yes, I have one question. Okay, sir, regarding cybercrime, suppose hypothecated in hypothecation that.
Yeah, please bit louder and.
First.
Hello.
Just raise your hand so that we can. Okay, yeah, please.
I may be Indian national or foreign national, but I live in a foreign country which India has no reciprocal arrangement.
Yeah.
In that case, I committed a crime through cyber.
Yeah.
In India.
Yeah.
I live in the foreign country which we have no reciprocal arrangement with India.
Yeah.
Then what is the mechanism of punishing him? Even if we completed the trial and sentencing him in his absentia, then what will be the procedure where there is no reciprocal arrangement?
Now you have to go to the BSA, which says that the territorial jurisdiction is not at all an issue. Isn't it? But still we can prosecute him if we can get the evidence. And now we may ask the question, since we don't have the MLAT with other country, what happens to the evidence? That's why section says that you can get the photograph or the video from the foreign country also. You need not to necessarily go to that country if there is no MLAT, mutual legal assistance to say, but you can ask the police officer, even if the fugitive offender is there, just to send the electronic means the photos and the videographs.
Not that point, sir. what I mean is this, that accused is still in the foreign country.
Okay.
Whether shall we use Interpol or not, or what is the procedure? If we send something, depute one officer from India, there will not allowed, as there is no reciprocal element between the country, these two countries.
Yeah.
At that time, how to execute the sentence to that very accused, who is living in the foreign
Yeah.
country we have.
Yeah, it is, no, now if don't have the MLAT, mutual legal, then it is very difficult to get the extradite of that person. That is the problem. But nothing bars us to prosecute him. Nothing bars us to prosecute him and frame the charges because section 356 is there, trial in absentia. Yeah. Another question, please.
Another question.
Sir, kindly explain how
This
to
may be the
seize-
last question, sir.
Kindly explain how to seize electronic currency, that is Bitcoin and all, from the possession of accused wallet.
Wallet. Of course, cryptocurrency, I added something on the this one. See, now the cryptocurrency, just hold on. See, now the wallet is of two types. One is the hardware wallet and another one is the software wallet. Now, what happened earlier is that KYC norms were usually not followed by a currency called Monero. But now they have to follow the KYC norms by all the agencies. Now, what has happened? I will take only 2 minutes. Before some 2 years back, cryptocurrency was considered illegal in India. But one of the Bombay Association has approached the Supreme Court and they got a favorable order stating that investing in crypto is not illegal. There the Finance Minister of India has come up with 2 provisions in the budget. What are those? One is that whatever the money you invest in cryptocurrency, 1% TDS, tax deduction at source. Number 2, 30% on the profits earned on cryptocurrency with no set off and set on. What does it mean? 30% on profits earned. For example, today I put 100 rupee currency on crypto. Tomorrow I earned another 100 rupees. So on 100 rupees I earned, I had to pay straight away 30 rupees as tax amount. With no set off and set off means in GST, goods and services tax, for example, I have earned some 10,000 rupee profit last year. That 10,000 rupee profit can be adjusted for next 3 years for the losses to be incurred. That is called as set off and set on. Similarly, if I have incurred losses, that can be shown against the profit. But here, that is not there. Today I earned 100 rupees in crypto, pay 30. Tomorrow I lost some money, I cannot adjust. Chala gaya to chala gaya, aane wala, that day, that one. That is the thing. Now crypto, now what happens is that you have to use a specific, all the addresses and all those things. For example, Binance and all those things, and you have to take the crypto wallet addresses and the transaction addresses there. Addresses are usually 95-digit alphanumeric, that you know, in the crypto, this one. There is a specific software and also in IFSO, Intelligence Fusion and Strategic Office, that is there under the Delhi Police. There is a specific, this one there, that will give the, all the cryptocurrency transactions of a particular person. What does it mean? For example, 1 Bitcoin I purchased. I sold it to this for 100%. Cutting. Then each currency, where all it goes, then the back addresses, everything can be given by the crypto valence address that says that this one. Second thing, as I told in the morning, yesterday, now everybody has to put up definitely the KYC addresses for a cryptocurrency investment. What changed means, earlier cybercrime fraudsters, they used the mule accounts or the rented accounts. Means, I have some very old person sitting in somewhere in Manipur. Take their bank passbook, ATM card, everything. Do a cybercrime, put the amount there, take there. I will give just 1,000 or 2,000 for that person, account holder. I am using those accounts. That is called as mule or rented accounts. But to prevent this one, proper KYC came. That means to say that myself cannot invest cryptocurrency for an account belonging to any other person now. Now I can invest only in my account using the virtual account or whatever the Binance or the hardware and all those things. Number one. Now, what is the latest modus operandi by the fraudsters? They know that they can only open their account against their own ID. What they do, they will come to Manipur, Imphal. They will get a rent agreement or rent place somewhere. They will make a rent agreement with one of the landowner. Based on the rent agreement, they change the Aadhaar address. Based on the Aadhaar address, they open a PAN account. Based on PAN account, they open a bank account. Now everything ready. They do a cyber fraud in Manipur or wherever and put the money, take the money. On one fine day, within 15-20 days, they just vacate the house and go. Now what is this one? I have the Aadhaar card. I approach UADI. But the problem with UADI is that they don't give the past addresses. So they only give which address this person used for opening account in the Aadhaar. They don't give the earlier address which may be of anywhere. They don't give this. This is the major lacuna that is there, especially even in cryptocurrencies, to find out where the accused fraudster has gone. Yes.
Thank you once again, sir. So this is the last question. So I hand over my to Hilton.
Sir, I have one question, sir. Sir, could you please elaborate the exact time, time for before sunset or after sunrise, regarding in connection with the arrest of the accused woman?
Okay, arrest of the accused woman.
Yes.
Yeah, see, morning also madam was telling. Can you tell me what is the exact time to be arrest the accused woman?
No, but we still do not know. How can we determine the exact? How can we determine the sunset time or after sunrise
Yes,
or
yes,
sunset?
yes. Sunset and sunrise.
So it is difficult. So could you please elaborate?
I think there is a particular department which says, and even in the Google also they refer to the particular time, what is the exact sunset time and the exact sunrise time for the every day and all those things. That should be followed. And morning, madam was telling, and it is also in the law, only in that day only you have to arrest the woman, number one. There is a only arrested by the woman police officer, number two. And there should be a presence of a woman person also, this one. But in rarest of the rare case, if you don't find a person, if you don't have a woman police officer, although the arrest means actual touching of the accused, if it is such of an importance that is of national interest, or she may commit of a offense of that grievous offense, still with reasonable following the reasonable this one, arrest can be made by a male police officer if such of a this one. But only thing is that we need to be explained to the court why it was such an imminent this one, why it is imminent danger, and even without the availability of the women constable also, then why an arrest has been made. We need to be ready to explain that one. That's why the word save in exceptional circumstances, it is there in that section.
Thank you, sir, for the insightful, enlightening session. It was a delight to listen to, sir. I'm sure you will all agree with me that it was like an action-packed movie. From the beginning to the end, it was exciting. I once again thank Shri Rajasekhara and IPS Director CDTI Hyderabad for the wonderful session. And I also thank the moderator Shri C.H. Momon, Professor LMS College, and panel advocate MASLSA for moderating the session. Now we will have, I would like to request, we will have a 5 minutes of feedback session. I would like to request 2 volunteers from the participants to kindly share feedbacks, your suggestions, your experience of the 2 days orientation program you may please come to the stage and share your feedbacks. Any two volunteers. Or you can also share from where you are seated. I think there are some, but they are still undecided. Please feel free to share your feedback, suggestions.
Good evening, myself S.K. Tyagi from NIA. Basically, I have attended both the days session.
Can someone please pass on the microphone to sir?
Hello. Are you getting? Actually, myself S.K. Tyagi from NIA. Basically, I have attended both the days session. In the morning session yesterday, there was a session in local language. That was a problem for me.
Certainly.
Otherwise, it was nicely managed, and each and every lecturer was very good in explaining each and everything. Particularly Miss Neera yesterday, today morning Shruti ma'am, and no doubt Mr. Rajasekhara has given a wide view. He has given a spectrum of knowledge within such a short period of time. I really appreciate this type of classes keep on going on in future also, so that all the persons who are dealing, whether it is judiciary, whether it is police persons, whether it is advocates, may be enlightened and improve their knowledge and may present their cases accordingly into the court. I really thankful to Mr. Rajasekhara that he has given such a wide view about this particular session. Thank you. Thanks a lot.
Thank you, sir, for your valuable feedbacks, and your suggestions are also noted. One more volunteer, please. Yeah, there is one here, in the middle row. Microphone, please. In the middle row. Second in the middle row. Second row, da. Somda.
Ngarangdagi chatharakpa asumba orientation program si aduki matik akoigi lakpiriba ngasibawda delegation si aduki matik yami adu yamagasu ngarangidi yam full loy ngasigina amu khara yawdabudona tawba aduna ngarangi session do aduki matik akoigi maman yami akoigi feedback haibabu isema MASLSA haibiramba magi BNSS bo koin CRPC yamazena takhairame yamazena tambirame madugi damta akoi nungai tawdabo adudagi akoina khangaubuda ngasigi amu hoigi sar kenosiga amu yengnaruba kanda nupi maga nupa maga hoigi resource person lakpase siga mu akoina phangmaganda aikoigi lairiba jiki home department DGP dagi hauraga home department law department gi yamna maruiba pot khara anova law si chanar ko matamda manungda state na hapkadawa pot khara lai haibase machai thamjagi ahamada hajiki hariba metren haibadi videography adagi laptops mobile haibo mayam aji digital mayam singse masi provide tawgadra tawroidra haibana singse masi ama yam thuna 6 months ki manungda masi thambiba haibadi home department law department today layhanning by tare or tamaning about Pazana investigation hope we are never. Has you put the take that tauri? As I moved the hang with that zero in no less. I win a tower. I give me a ham high jodre. I give Ming Kojam Project. My name is Kojam Project. I am the Special Public Prosecutor, Government of Manipur. Now I am posted at Manipur Human Rights Commission. And I am the Special PP in the MPs and MLA also. Aduna, I am hiding Bana, Kangjaning Bana, Kanganing Bana. High will law say, do him a tick lure, and the evidence kimatangida. Masibo da Manipur fail where Kanomayam say, criminal trial the imprisonment conviction people say, investigation shown with the Guinean, highlight evening. Other Anovala will law see the Amina, shown another Macha Amana, as he had equipment, ma'am, kids, ma'am, sings here. Bibi Mama. Tambi Mama Zangi have a set. I can see me from the approved to Honningham. Ma'am Janinger, Kuakubio, Yaninger Toki. Number one. Number two, Gasi police ki the ampazare, awareness of say, orientation say. Matang the lawyers, Lishingani and Lady Vini. Amuk shoot the Honning, Tatuk Lega, Moko Yauraga. Masim Tanga, Matanga. Orientation se extent of view Manipur State Legal Service na and Hyjeri. Thank you.
Thank you, sir, for your...
Long-term supplement of the way Yagadra.
Yes, please.
Yeah. Now we have new law enforced and enacted, but we are given orientation course in such manner. We, the police officers, lawyers, and judges, we are in the advantage group, but law is enforcing after passing the acts in the parliament. What about the peoples in the remote areas? Mere publication in the Gazette, shall we presume they know all these laws? Whether we enforce these laws, ex parte decrees to the people. Shall we presume they know the laws in the remote areas of these countries? So I want justice to the doorsteps of the people, if possible, to enforce such new laws. If required, law commission may recommend such things. Otherwise, to implement this law, there should be many abuse of the laws in the country. I want to give this much feedback, because people need to know the laws. If the people are not knowing the laws, there is no peace and development in this country. So, awareness of the people of the enforcing laws is very much necessary. Thank you.
Thank you, sir, for your valuable inputs and suggestions.
Can we have one last from the police side? Excuse
1
me.
minute, please. 1 minute.
Yeah, here, this side.
The deliberations were all good. Actually, the 2 days has been very, it's been an eye-opener exercise for, I think, for most of the IOs and many officers attending this 2 days training program. And at the same time, we've had like several small discussions that are on district levels and units. But I think this is more systematic and organized and well-packaged 2 days program. I'm sure, I think many of the IOs will really benefit, and as a supervisory officers, I think we'll also benefit from these 2 days. And I think the tea, snacks, and refreshment and other logistics were all very well. Hopefully, the books were also provided, but I think it's being taken away. So I think, but at the same time, I wish we have like maybe in next sessions, maybe like if there is a follow-up, as mentioned earlier, like maybe 5-6 months later, if there is some sort of follow-up, and if we have, like say before the training sessions, if we have some pre-tests and post-tests, you know, where so that we know where the IOs and other officers and other learned people are also coming, what kind of knowledge they come, and maybe that's how you, then maybe you could have tailored the training package for better, you know, in the next training sessions. But at the same time, as you said, as many learned also have informed that, I mean, obviously, yes, investigation is one reason, very shoddy investigation that happens is one reason for lots of cases, failure as well as pending. But at the same time, I think at this moment, even prosecution, I think, is having lack of infrastructure, manpower, and I think that's where the coordination between the police investigation and even the prosecution units have to work in close coordination. All these three units have to work closely so that with the coming of these new laws and new challenges, I mean, it's going to be very difficult, I mean, we need to pick up things very fast so that, you know, it doesn't become a double jeopardy again to add on to the already existing limitations that we already have in the field. So I hopefully MASLSA can actually maybe resolve, or maybe be the proponents for kind of advocating for as the new equipments or other things which prosecution needs, which the police will be need. I think that can be advocated from MASLSA side also. That's all I want to say. Otherwise, it's been very wonderful experience, and I hope we all had good learning experience. Thank you so much.
Thank you, sir, for your valuable feedback. I'm sure MASLSA and the law department and other concerned authority have taken note of the suggestions and feedbacks and will implement it. And we certainly will look forward to another such orientation program in the days to come. Before we conclude, I would like to request Srimati Rajshri Yambem, Deputy Member Secretary, Manipur State Legal Services Authority, to propose a vote of thanks.
A very good evening to everyone. We have come to the close of a very intensive and exhaustive 2 days orientation program on the new criminal laws. As we conclude, I would like to extend our heartfelt gratitude to everyone who contributed to its success. At the outset, I would like to thank our Honorable Chief Justice, High Court of Manipur, Honorable Mr. Justice Siddharth Mridul, Patron in Chief of MASLSA, and Honorable Mr. Justice A. Bimol Singh, Judge High Court of Manipur and Executive Chairman MASLSA, for their leadership and guidance throughout. I would also like to thank Madam Eno Shitombi, Commissioner Law, for the constant support while organizing the orientation program. I would like to extend a sincere thank you to our resource persons and moderators, especially Sir Rajasekhara and Shruti ma'am, who have come in especially for the program. Your expertise and thorough analysis have provided us with a clearer understanding of the recent legal changes and their implications. Your time and effort are deeply appreciated. To our delegates, judicial officers, police officers, learned members of the bar, LADCS, officers of prosecution department, customs, forest, forensic department, faculty law colleges, NIA narcotics, NELIT, media personnel, thank you for your active participation and engagement. Your thoughtful questions and discussions have enriched our program. I would also like to thank the staff of City Convention for the constant cooperation. I would also like to sincerely thank my colleagues J. Hilson Angam and Patsamam Praveen for conducting the 2 days program so seamlessly. A big thank you to the technical team and the staff of MASLSA and the High Court for the hard work put in to make the program a grand success. To conclude, let us carry forward the knowledge gained over the past 2 days and continue our efforts to ensure that the new criminal laws are understood and effectively implemented. Thank you all once again for your invaluable contribution. Thank you.
Thank you, Srimati Rajshri Yambem, Deputy Member Secretary, MASLSA, for the vote of thanks. We shall conclude the session here. As we moved out, tea will be served in the lobby, in the ground floor. So I would request all of you to please enjoy the tea before leaving. Thank you.